4. It was actually fixed for today, but it did not come up with other cases. Matter may be
Other
listed.
cases means
Section 30, item number 32, 33, and 34 was already fixed for CD regarding the same PS case number and GR case number. So it was yesterday, it was fixed for today, but it was not listed in the supplementary list, unfortunately, by mistake, most probably.
Well, with regards to item number 65, my lord, we have filed an additional affidavit. I may be allowed to bring it on record, my lord.
item.
Orders, my lord. Supplementary.
Yes, all right.
May I please, Your Lordship? I beg to mention item number 37, my lord. The conducting advocate A. Mannap is out of station due to his treatment, my lord. The matter may kindly be action. It may be listed after vacation, my lord. Vacation, any date, if possible.
May I pray for listing of a anticipatory bail application, my lord, on day after tomorrow, Lordship.
Go to senior bench.
Lordship, actually, the co-accused has been granted bail by your Lordship, so it may be come up with your Lordship.
But still you have to make the mention there. After that it will be patient there.
Obliged.
Please, your lordship. Also, I beg to mention item number 15, lordship. Case diary was called for, but case diary is not available as per the instruction, lordship. The date may be.
All right, 15 after vacation.
Circuit file, lordship.
Arshit file.
Lordship. Bye.
As LCR may be called, trial court record may be called for in that case.
All right. CS file.
Yes.
File CS number.
Case number 73/2026. Dated 28/5/2026.
From NDPS, NDPS special, NDPS court, Kamrup Metro, lordship.
And copy of TCR along with CD.
Deeply obliged.
May it please, your lordship. Lordship, I am praying for listing of a regular bail application, my lord. As other two cases listed before your lordship tomorrow, my lord. Same FIR, my lord, for CD, my lord.
Listed tomorrow.
Yes, before you
Or
lordship,
fixed
my lord. As
tomorrow.
item number 27 and 28. Tomorrow's list, my lord. Before you lordship.
Tomorrow's list is already out.
Yes, my lord. Therefore, I am praying. Obviously.
May please, your lordship. In item number 11, lordship, I am praying for a short accommodation, lordship. Today some difficulty, lordship. Could it be taken up after vacation on lordship, 15th of July, lordship? 15th of July, lordship. Obliged.
Item number 8 of today's list. Can it be posted after vacation? Today I have some difficulty.
All right.
Obliged.
May it please, your lordship. I beg to mention item number 24, lordship. Kindly fix it in after vacation, lordship. If there is there, lordship. 24. There is there, lordship.
Interim is there.
Jay Masan, you don't need. Ase? You don't know. No, interim is not there. I think that
No interim.
Friday. After vacation.
After vacation, lordship.
Send it
To
back.
send back.
Send back. It's not after vacation. Send
so
back the
that-
CD for resubmission on the next date fixed.
Wait, please, your lordship. Lordship, I'm mentioning item number 21, your lordship. May the matter be fixed after vacation.
All right.
There may be continued, your lordship.
20?
21.
21. Lordship. Case file, lordship.
There may be continued.
All right. Some TCR, okay?
There may be continued, your lordship.
Search sheet number, lordship. Search sheet number
May I please?
11117/2026 dated 02/05/2026.
May I please, Lordship?
Man decided to
I beg,
20 July.
I beg to mention item number 42, Lordship. Step taken today, Lordship. File clear, but some do.
Yes, huh?
Step today, filing, Lordship.
Please be clear what you want. We can't understand you.
Step taken today, Lordship. Some problem earlier, I could not.
Submitted that steps have been taken only today. Hence list the matter again.
Yeah, please, Your Lordship, with your permission, I mention item number 14. I seek adjournment for.
40?
Item number 14, 14.
Yes,
One.
after vacation.
May I mention item 7 on your lordship's board today? There was an additional affidavit to file. This is a matter from Delhi Millets. I'm the appellant who's in Delhi, and I filed this RFA against a court ex parte judgment and order of dishonor from the local courts, Millets. Because your lordship may just permit that additional affidavit to be taken on record, and if your lordship can take it up as early as today, I will be grateful.
Your Lordship, I am for the respondent here. They file a additional affidavit, Your Lordships. I want to reply.
Well,
No, they bring they bring some of the things, Your Lordship, that has to be replied.
Millets,
So let the date may be fixed for that.
Millets, in any case, the matter is listed before your lordship. I've come all the way from New Delhi. The lordship will just take it up whenever it is along with the affidavit, and he can make his submissions there. Why do it at mentioning
My
stage?
humble submission, Your Lordship.
All right, let it come. What is the
Let it come
difficulty?
along with the affidavit.
May it please, Your Lordship. Sorry, my lord. But I beg to mention
I am the.
item number 12, my lord. Only after vacation, my lord, if possible.
All right. Vacation.
Deeply on.
May I please, Your Lordship?
তো এই দেখুন এডিশনাল এফিডেভিট এখন দিল্লির পৰা অহা বুলি যে ক'লো
And this is regular bail application, Lordship. In this case, Lordship, the another co-accused bail petition is fixed on day after tomorrow, Lordship. But my little submission is that, Lordship, the FIR name accused number 1, 2, and 4, 5, Lordship. There is the altercation took place in his house, Lordship. But I went to the house of the accused number 5, Lordship, in the FIR, and he is my father-in-law, Lordship. On the date of 28, Lordship, each celebration is there, Lordship. On invitation, I went to their Lordship. But the altercation took place, Lordship, but the accused number 5, his 2 sons, and my younger brother, informant, and his 2 sons, Lordship. There are some altercation took place at night, 11 p.m., Lordship. And subsequently, Lordship, this FIR has been lost, Lordship. In this regard, Lordship, the informant already submit one affidavit, Lordship. The petitioner and the FIR name accused number 5 was not there, Lordship, at the time of altercation, Lordship. And he shown this affidavit, Lordship. But original copy, Lordship, I have submitted in the court below, Lordship. That is why, and today I have placed the photocopy, Lordship. But otherwise, the present petitioner and he went to his in-laws house, Lordship, and his involvement is not there, Lordship, at all. And in the affidavit is very clearly mentioned, Lordship. I am in 24 days in custody. But it is admitted fact altercation took place. The FIR name accused number 5 and the informant son, Lordship. They are the own brother, Lordship, younger and elder brother, Lordship, and they are the cousins, Lordship. And the FIR, Lordship, and there is nothing in specifically who assaulted, but I was not there at all, Lordship. Kindly consider the affidavit, Lordship, placed by the informant, Lordship, shown by the informant. But dispute is going to happen in the house of the informant, Lordship, and my father-in-law, Lordship, FIR name accused number 5. That day, Lordship, and the Idul Juha Lordship, the celebration is there. And on invitation, I went there, Lordship. And subsequently, I leave my in-laws house, and later on, Lordship, altercation took place. Subsequently, again, I went to there and for settle the matter, and even then I went to the medical also, Lordship. And I'm very clearly mentioned in my petition, Lordship. I went to in-laws house, Lordship.
Yes.
CD, Lordship.
My involvement, Lordship, and I went to the in-laws house, Lordship. I have left, and after invitation, Lordship, and Idul Juha is there on that day.
Why would the
Lordship.
police arrest you?
No, Lordship, and I voluntarily went to the police station for for query the case, Lordship. That because my father-in-law is the FIR name accused number 5, and the informant is my also the FIR name accused number 5 say younger brother. Their dispute, Lordship. It is admitted. Marpit is there, Lordship.
Admitted fact that it is dispute between the family, Lordship. It is there. It is there, but the real issue is
How many days now?
And 24 days, Lordship.
Huh?
24 days today,
24 days.
Lordship. But I am son-in-law, Lordship, but my involvement, nothing. I voluntarily went to the police station, Lordship. But I do not know my name is incorporated in the FIR, Lordship. Even I have been arrested.
Let's grant interim then. Because otherwise it will be another 3 weeks after vacation.
as Lordship.
Adlanet Council for the petition. This is an application under so and so. The allegation pertains to assault committed upon the of the informant by the petitioner resulting in serious injuries. An affidavit has been filed stated to have been sworn before the notary public Kamrup at Amingaon by the who is the informant, Marjina?
No, Lordship, and Syed Ali Bhuya.
Who is Marjina? Oh, no,
Martin
this is the
Lordship,
advocate.
and he identified the Lordship.
By Syed Ali Bhuya, the informant, wherein it is stated that the present petitioner is not involved in the alleged offense. Where a call for the CD in regard to the above, it is provided that provided in the interim that the petitioner shall be released on interim bail of ₹50,000 securities of like amount to the satisfaction of the concerned authority. Which court is this?
Chief Judicial Magistrate Kamrup Amingaon, Lordship.
Provided that the petitioners cooperate with the investigation, intimidate the witnesses.
Deeply obliged, Lordship. Deeply obliged. And I am sorry, Lordship, item number 4, Lordship, and he is my wife, Lordship, and his name is also there, and that is AV, Lordship, out of same FIR, Lordship. Item number 4. And he is the wife of this present petitioner, Baharul Islam.
He is also named.
FIR name, Lordship. His
4.
name is also.
Item 4.
And his Lordship and the GP councillor, Lordship, elected GP councillor for last year, Lordship, and holding his post, Lordship.
And he's all. She. And he's my wife, Lordship Barnes. His involvement is does not at all, Lordship, but his name is only not here. So, protected, Lordship, I will be cooperate, Lordship, with the investigating agency, Lordship. Any condition, Lordship, lady, Lordship. And I am the mother of 2 children, Lordship, and my younger child is class 3 and elder one class 8, Lordship.
Right, same as item number 1, but for the facts. And up to affidavit, okay?
Here, injury report, Lordship. Lordship.
Affidavit is not in this case. Okay, in case of affidavit, you can say same affidavit is filed in this, the same, let it remain that way. The CD. Getting pre-arrest bail, instead of bail, to the satisfaction of the arresting authority instead of season. I mean,
Deeply obliged, Lordship, deeply obliged.
CD along with injury report, okay?
Obliged.
Both cases.
Obliged.
21-6.
May I please, Your Lordship? So item number 2 and item number 3 are arising out of same FIR, Lordship. So Lordship will find the FIR on page 17, Lordship. Lordship, the gist of allegation here is that the complainant itself is the police officer and the present petitioner and from item number 2 and item number 3, Lordship.
Anyway, CD.
Lordship,
This color and everything is there.
Lordship, that is there, but they have valid license, Lordship, which I have annexed, Lordship, and they are retired person from BSF, Lordship. I have also annexed their IDs, Lordship, on page number 37, Lordship. Both the persons are from item number 2 and item number 3 are retired from BSF, Lordship. His ID is on page 37, and the license is valid up to 2026. And even if section 30 of the Arms Act, which has been implicated in this case, carrying of armed license is not illegal, Lordship. The section 30 will not come of Arms Act, Lordship, in this case, Lordship. And otherwise,
Lordship, the Gauhati is there, Lordship.
preparation for Gauhati. And the,
FIR, Lordship. Lordship may peruse the FIR, Lordship.
and the complainant is the police person itself.
CD, Lordship, only CD, Lordship.
Allegation is preparation for Gauhati. 310 subsection 4 says preparation for Gauhati. And the arms that he is carrying, he has a valid license and he has been retired from BSF, Lordship. He holds the armed license because once retired, Lordship, this person tend to get engaged in private security firms. So he is willing to get engaged. So he took out this license so that he can further get engaged in any service, Lordship. Other than that, Lordship, that 3104, Lordship, it says about preparation for Gauhati and the license is valid, Lordship. And the other person from item number 3 has been arrested from his home while the petitioner from item number 2 has taken his name. It is there in the FIR, Lord. The reputed persons of our society, Lordship, they have from forces, Lordship, now retired. This statement might come some co-accused statement of item number 2, who has implicated item number 3 petitioner. Other than that, the complainant is itself the police personnel and the seizing officer also, Lordship. There is no chance that these persons will escape the trial, Lordship. while they were sitting at a dhaba, they have been not at a suspicious location. While they were sitting at a dhaba, they have been arrested, Lordship. There are other accused also who are involved in this case, who are there in the dhaba. Against them, some other case are registered, but not against this petitioners, Lordship. That is there in the ground, Lordship, ground of arrest. Forwarding part, page number 25.
FIR on being intercepted and charged in presence of independent witness, the following articles were recovered and seized: white scissor so-and-so, pistol bearing so-and-so number with two. Lordship, carrying a pistol with them, a retired officer, what is the use, Lordship? So let the CD be there, Lordship. At the right moment.
There appears to be some material for preparation of dacoity. This
Lordship.
Arms Act does not prohibit him from carrying, Lordship.
Lordship, then
kukri is there, butcher's knife,
everything's
cutters.
there, Lordship.
It's not just a matter of the pistol.
Item number 3, Lordship, only on the basis of co-accused statement. Yes, seizure witness are there because the seizure has been made and witnesses are there. Item number 3, only on the basis of co-accused statement, he has been arrested.
There was a group called.
Initially, arrest will be made definitely on the basis of co-accused statement, but if anything else is there, that only the CD will reveal.
The date of reopening then, Lordship, 13.
Yes.
Not 13, Lordship, let it be on 14, Lordship, because immediately opening day, we may not get all the CD. 14, Lordship. 14.
Both the item, Lordship. Deeply.
2 and 3.
This matter may be taken with item number 19, Lordship. Connected matters.
With 19.
Yes, Lordship.
Right. Now,
Now, Lordship.
Available in 19, Lordship.
let it come up.
Obliged.
Wait, please, Your Lordship. It's a pre-arrest bail, my lord. Your lordship will find the FIR, my lord, at page 18, my lord. 18, my lord. But I am on behalf of that, my lord. Last line, my lord, Asifur Rahman, my lord. And this FIR was lodged by, my lord, one Amarinder Lokor, my lord, Chairman, Rongyam Municipal Board. And the FIR starts from the next page, page 19, my lord.
Yes.
May I read, my lord?
I think this was somebody moved. Bail application.
My lord. My lord, this is the first time, my lord.
No, he had a similar case.
I have
Anybody arrested in this case?
No, my lord, this is a AB, my lord. No one is arrested, I think, my lord.
Yes, I remember distinctly reading this affair a few days back.
I have narrated my facts, my lord.
So many accused are there.
Yes, my lord.
So somebody may have moved for somebody.
I was a bystander, my lord, that place, my lord. And my lord, in fact, my lord, the CCTV footage are also there, my lord. If my role is can be my identity. But I have narrated the fact, my lord, at page 6, paragraph 8, my lord.
Because I remember this name of this dhaba, Rudramani Dhaba.
Yes, my lord.
You remember one order there, can you say, huh? We'll take it up later. Because we don't want to pass contradictory orders, we want to know what was there. Act two.
Please, your lordship. Lordship, the matter will be kindly passed over for time being.
Where is it listed today? Correct, time being. It's too early for it to come.
Oh, we'll wait, we'll wait. Whenever 2 o'clock, your lordship will take it up at 2 o'clock. Very well, much obliged.
This is an appeal, Lordship. I'm a appeal against the judgment and order of the learned member MSP Bob Peterson. Lordship, in spite of the fact that he is an employee of Aranya, drawing 45,000 something salary, but that evidence was not considered and only nominal income was taken. And ultimately 11 lakhs was awarded as compensation, although he is entitled to as per our.
So you're on quantum,
Lordship, yes. Yes,
not
Lordship.
insured. Vehicle is not insured.
Not insured. Insured, Lordship.
You are against owner or who is this?
Against the judgment, Lordship, on quantum. The
No, no,
quantum.
respondent is, seems it's a private person.
No, Lordship. Second, Lordship, National Insurance Company. 2 is.
Number 2,
Yes.
who has been made liable to pay?
Lordship.
Insurance company or
Lordship, just. Lordship page 86, Lordship. So Lordship page
because
83,
normally
Lordship.
Penny is the first respondent anyway. Heard Mr. Counsel for the appellant, this bill has been preferred against the so and so. Bill is admitted, call for the TCR, issue notice. Respondents steps by speed post AD within 3 days, list again after.
Please, your lordship. This is an appeal filed by the Lordship Insurance Company, Lordship, against the judgment passed by the learned member MSCT Goalpara, Lordship. Your Lordship, the insurance company filed the appeal mainly on the ground that Lordship, the driver who drove the alleged offending motorcycle, Lordship. He had no driving license at all, Lordship.
What is the IA about?
About a stay, Lordship. And secondly, Lordship, the injury assessed by the doctor left femur, but tribunal assessed considering it as a right foot, injury in the right foot. Wrong, Lordship, assumption.
Same order.
Accordingly, I ordered.
The previous one.
IA is there, Lordship.
IA will consider after receipt of TCR.
Lordship. Must oblige.
IA read part so and so. IA will be considered after receipt of TCR.
Must oblige, Lordship.
May I please, your lordship, kindly pass over the matter for time.
Did you receive?
My lord, this is scan copy, my lord. It's a charge sheeted case, and also my lord, charge framed on 19th January, my lord. Thereafter, it is in not in progress, my lord. But it says it's a commercial quantity. Later, my trial go on, my lord. Too early, my lord. I have
He's praying for some time.
time slots.
Fire at page number 10, ma'am. Well, here in this case, my lord, my contention before your lordship, my lord, section notice under section 48 was not served, my lord, on the relatives, my lord, but it shows that it was communicated through WT message, my lord. My lord, page 19 is the 48 notice. 19. Would say it's a signature part, my lord, under heading signature part. My lord, may I read my page 1. Signature could not obtain, hence WT message so and so has been sent to the local PS for informing the family members regarding the ground of arrest. That mode, my lord, regarding this issue, this honorable court, there is a coordinate bench order is there, my lord.
Who signed
No, there is no signature, my lord.
the?
Only accused signature is here. Abu Bakr
Anything to
Siddiq is
show
the-
that it was received?
Yes, lordship. A 48 notice has been served, duly served. Relatives and their signature has been taken. That is in respect of accused number 2, Abdul Qadir. And so far as accused number 1 is concerned, also.
Vidul.
Yes, Lordship, Abu Bakr. Jahidul Islam. Here, Lordship, there is a note. Copy sent to Maqbul Islam, Huya, brother of the accused person, through his WhatsApp message, WhatsApp number so and so, on 23rd 04 2026 at 4 o'clock. Lordship may go through.
My lord, I am having the certified copies, my lord.
Hmm?
I am having the certified copies of 48, my lord.
I'm also submitting from the records.
It was procured, my lord, on 4/5/2020.
The same day.
I am sure there will be no distinction between the certified copy and what is there in the record. But
My-
submission is something else regarding.
Detective 1, Abdul Qadir, accused number 2. Signature is there, Lordship, of the relatives. And so far as accused number 1 is concerned, Zahidul Islam.
Who is the petitioner here?
My lord, Jahidul
Islam,
Islam and
yeah.
Abdul Qadir.
And Abdul Qadir. Commercial quantity, Lordship. And 1,350 bottles of illicit cough syrup. Each bottle contains 100 ml, Lordship. That has been illegally transported from Gauhati to Agartala, Lordship. And that illegal drugs has been By police intercepted the vehicle and therefore were recovered those articles suspected to be drugs. Lordship,
So,
without
Zahidul,
acquisition.
this Zahidul, you were speaking about, have you flag marked?
Yes. So Lordship, when you turn to page 48, the last page of the notice, there's a note from the IO that 48 notice has been sent to the brother of the accused on his WhatsApp on the same day, Lordship, that is on 23rd/05/2026. That means sufficient intimation has been given to the relatives, Lordship.
This 48 notice,
Yes. Can you turn the page? In respect of accused number 1, Jahidul Islam. Mission was done to his brother also on the same day. The huge consignment, Lordship, 1,350 bottles of cough syrup, Lordship, illicit cough syrup. Suspected contain of codeine phosphate, Lordship. Commercial quantity, Lordship, that is recovered from their joint possession. And they themselves admitted the fact that they are the drug peddlers, Lordship.
so if you have been sent the whole notice by WhatsApp, what more is required?
No, my
Right,
lord,
Lordship.
48
Application
notice,
is done.
I have obtained certified copy, my lord. Page 19 onwards now.
You may have the copy of the notice.
No, my lord.
The question is whether it was sent or not.
My lord.
Any defect in the notice itself?
My lord,
Any defect in the notice?
my lord, 48 notice, my lord, page 19, my lord.
Huh.
It, at the top, my lord, it was sent to Jarina Khatun, my lord, page 1919, my lord. And this certified copy was procured on 4/5/2026, my lord. Page 19, my lord. At the top, my lord, name include alias, my lord, Jarina Khatun, my lord. Now, my lord, service notice signature was could not obtain, hence WT message sent to sent.
Okay, this is to Zorina Khatun, but who is this Mokibul Islam Bhuya? He's your brother.
Brother of the
Now, my lord,
Jahirul
these are,
Islam Bhuya,
my lord, these are afterthought, my lord. When, my lord, the investigating authority.
It's a matter of bail, Lordship.
Now, my lord.
What is there, I'm submitting from the records. And so far as the record
Page
concerned,
19, my lord, I could let me
notice
submit.
48 is duly complied with, Lordship.
My lord, page 19, my lord, clearly these are not certified copies, my lord. Now, subsequently, this may be, my lord, prepared. Now, my lord, page 14 and 21 also, my lord.
That is a matter of
21 also, my lord.
whether it is
Let
correct
me-
or incorrect, Lordship.
Page 21 also. my lord.
What page 21?
Page 21 is, my lord, 48 notice, my lord, to the accused number 2, my lord. They are also similar, my lord. There is no signature of the person who has received it, my lord. Only it was mentioned that it was through signature could not be obtained because it was sent to my lord WT message.
WT message was sent on 2304, Lordship. But the signature of the relatives was obtained on the next day, Lordship.
And this certified copy was procured on 4/5/2026,
That note is there,
my lord.
Lordship.
Certified copy was 4/5/2026, my lord. Now, my lord, apart from this, my lord, arrest memo, my lord. Page 23 or not, my lord. My lord,
As far as this Zahidul is concerned, so according to the IO, it was sent on 23 itself by WhatsApp. And as far as the other is concerned, that is also there. His signature is there.
47
Now, my lord,
is duly complied.
this
with,
certified copy is of
This is violation of Article 21 and
4/5/2026,
22
my
of
lord.
Constitutional.
My lord, if arrest itself
Otherwise,
is
it's a
illegal, my
condition
lord,
to
there
be
is
watched.
judgment of the honorable as well as our court also, my lord. My lord, this certified copy is of 4/5/2026, my lord. I have applied for certified copy, my lord, on 29/4/2026, my lord. 4/5 it was furnished to me, my lord. There is no such, my lord, note, my lord. And apart from this, my lord, page 23.
Is there any printout of the WhatsApp notice?
No. No, that's it.
I have to say also, but that is not, I have not found.
That should be here. That will set at rest the controversy.
Another part, my
If
lord.
it has been actually sent, even now we can bring it out.
Lordship, we can wait.
Page 23, my lord.
Yes, page 23.
My lord, arrest memo, my lord. My lord, serial number 8, my lord. Name, address, email ID, whomsoever to convey the arrest information. My lord, one signature is there, we don't know him. But that column is also, my lord, serial number 8 is not filled up.
What do you want to say now? As far as this is concerned,
Which one, my lord?
whichever you are referring to.
My lord, this arrest memo, my lord.
Yes.
Relating for.
Yes, column number 8. What do you want to say? So what is your submission in this regard?
My lord, this there should be mentioned, my lord, whom it was served by. Who was witnessed, my lord.
The witness is there, respectable person of the locality where he was, where the arrest was made. According to him, that is the person.
Yes.
That is what is required. Signature of one person. Already check if any WhatsApp.
Lordship may give us a time, Lordship, and produce a, if it is not there, Lordship.
That is what I'm saying. First you check here.
Yes,
If you don't find, then
Lordship,
we can grant you some time to obtain the proof.
after some time.
Lordship. Quashing petition, my lord, filed by us in terms of a settlement that happened between the parties. Now, in terms of the settlement, my lord, we have already paid 11.25 CR. Subsequent to the paying of the money, my lord, we were actually agreed in the terms of the MOU to come and file this quashing petition. So it took some time for whatever reason, there was some delay, but the delay was in circumstance and we filed this petition. They have filed an objection to this quashing petition now, saying that there is a amount of a GST liability which arises for that period subsequently to acceptance of the money in the MOU. So therefore, they are not, they have filed this objection. Now, our contention is, my lord, the MOU now stands completely paid. All money that's agreed has been paid. There could be some claims afterwards, my lord. I'm not aware of it. That could be a genuine claim also. I don't know about it. But that would not stand in way of this settlement at least, because the money now is, everything is paid. And these notices which has now come for GST liability was for that same period. So I do not know whether it was there within the knowledge or not. But subsequently the notices have all come. That they have annexed in their reply, my lord. My settlement deed, my lord, is important. It's at page 124.
So I have to hear the matter today. It would not be possible because of ensuing vacation. We have a lot of miscellaneous matters to take care of.
I leave it to you.
So, respondent.
No, I think he was, Mr. Nayak was supposed to come. He's for the complainant. He said he's in court 1. Can then, if that's.
He also had short time to go through the case recorder as per the earlier order.
She's here.
Led by Mr. P. Nayak, he's on legs, my lord.
I think anyway, we won't have time to hear this matter today before the vacations. We'll post it after the vacations.
Should indicate any date if it is not.
Also heard learned additional people. The matter. Can you give a date
If
after
it is
the
possible,
vacations?
otherwise I leave it to your lordships. If it is possible, otherwise I leave it to your lordships.
If, what is possible?
If it is possible to give a date, my lord,
Yes, we always give a date.
grateful. My lord, the week after
Yes,
that. if
that
it
is why we asked, give us an agreed date.
I'm sorry, a week after that, if it is not problem.
Yes, give a date after that. Interim order postally to continue.
28, extremely grateful.
Yeah, please, your lordship. Lordship, the regular bail application arrested on 16/5/2026, 39 days behind the bar.
City was called for, that is not receivable.
The FIR is at page 12. Petitioner was driving a four-wheeler vehicle and he met with an accident and scooter, and due to that accident, the husband and wife died, and the father of the one of the victim lost the FIR, and it has been alleged that the driver of the vehicle was under influence of alcohol.
Three persons injured, lordship.
Hmm?
The extreme persons injured, 2% died. City will be required, lordship.
39 days already behind the bar, and
2 lives is gone. Lordship. The case study, lordship.
only an accident.
You will have to produce before the vacation then. Otherwise, statutory period will be over.
Lordship, yes. On 26th, we can have a try.
All right. We did not receive list again on 26th.
Much obliged.
Make this a lordship. Also, regular bail application. 30th of May was arrested. My lord finds the Ejar at page 12. The translated type copy. May I read?
Yes.
With due respect, I beg to state that the aforesaid accused person has been serving as a pharmacist at Borsola Model Hospital. On 30th May 2026 at about 11 a.m., the accused cooked beef at the canteen of Borsola Model Hospital and kept it in a cooking pan, karahi. Upon entering the canteen, the hospital staff noticed the said food item and suspected to be beef, whereupon they informed the local residents. The local people, after arriving at the place of occurrence, questioned the accused regarding the said food item, and on being questioned, the accused person stated that he was preparing beef. It is to be noted that the said act of the accused person disturbs the communal harmony in the locality where the substantial section of the people profess the Hindu faith. Keeping meat suspected to be beef in a public place adversely affected the sentiments of certain members of the public and hospital workers. Therefore, pray that after investigation of the case, necessary action may be taken against the accused person. Accordingly, the Dhekiajali PS case was received and registered under sections 299 and 196(1) BNS. I had also approached the court below, praying for bail, which was rejected by an order at page 22.
Could you find out if it was beef or mutton or whatever?
FSL is awaited, lordship.
May I pray one thing, if lordship permits me, Lord?
Admittedly, he has cooked the meat.
May I pray something? To দাঁড়াবেন, আমি বলবো.
Admittedly what?
My lord,
Beef meat, lordship.
Who admitted?
The accused, it's himself.
Yes, yes.
May I submit with all humility, my lord? There is one thing which is strikingly not in accordance with law. First thing, whether custodial detention is necessary, even if I've cooked meat, is one thing different. Second thing, police have seized it, and the seizure report lordship finds
at page 24. There's a relevance why I'm referring to it, my lordship. Kindly consider this for a moment. Page 24. Is it? The description of the seized articles, is suspected beef meat cooking with pan weight 415 gram and the dao and the spoon. No, my lord, with all respect, the power of search.
20 days now.
That is 23.
23.
Let me just point out one thing, the power of search and seizure in respect of a food, meat becomes a food, is not the police. Under the Food Safety Act, there are designated officers to do it, and it's not the FSL report we want. We need a lab report under the Act. Quite different. And the entire procedure, how the species of the meat is determined, is done by the manual methods of analysis of food. One page, and we have. So the person who did the search and seizure was wrong. The way it was been sent for the search and seizure for the determination is wrong. This, if I just point out. Page number 7. Page number 7.
But you want us to go through this whole.
No, I want to know that the mark page only. How they do it. This is under the Food Safety Act. The search and seizure was absolutely wrong, not warranted. It should not have been sent to forensic also, my lord. I just pointed out that mark page. Just the heading. Just the heading. Meat specification for the detection of the meat adulteration. Here, the first lines. There has been unprecedented growth in the food industry consequent to the growth demand of the quality food from ever-increasing population. Nowadays, consumers have become health conscious and demand quality food. Adulterated food often enters upon the food supply chains and jeopardizes the sentiments as well as health of the people. Substantial portion of the population has got religious considerations towards the consumption of meat of a particular animal species. There where I'm on, my lord. And derivation may result into detraction from its consumption. The meat adulteration has got into social, religious, economic, and public health concerns. On this page 74. How it is done? It has nothing to do with the forensic, my lord. Page 74. The chart, lordship sees.
You mean to say forensic does not have the capacity to carry out this kind of
under the law? No. This would be done.
What is that law?
My lordships. If lordship would have the Food Safety and Standards Act, 2006.
What does it say?
My lordships. No.
No. Does it stipulate any particular lab?
Yes. Yes, it does.
What is that lab?
The Food Authority may notify food laboratories and research institutions accredited by National Accreditation Board for Testing and Calibration Laboratories or any other accreditation agencies for the purpose of carrying out analysis of samples of food analysts under this Act. So this has to be accredited under the different laboratory, my lord. And here at section 31, I'll pass on the book, my lord. Extremely sorry they could not get the other book.
So does it oust the jurisdiction of FSL?
Yes.
Suppose FSL also has the same capacity.
Well, but FSL would not go for meat detection. This is under the Food Safety Act. Suppose a meat is detected at a particular restaurant, hotel, etc. What species of meat is there? It has to be done by polymerase chain. It is not whether the quality is adulterated or not per se. This takes to a different level. Therefore, the species, target, primer, direction, and sequence. The DNA sequence is taken. And therefore, it comes to cattle, buffalo, sheep, goat, etc. This is done under the Food Safety Act with the notifications I've said. There's a specific procedure, authorities. So the search and seizure is not even given there. But resting on that, that would be a different case.
FSL has the same capacity.
So far as this
is doing so many DNA tests and everything. Suppose they have the same capacity,
Yeah,
then
it
the
will.
law say,
But that would be an interpretation, but a jurisdiction for search and seizure is given to food safety officers and not to the police. Police has no jurisdiction to touch it. There's a manner and method of carrying it out, my lord. That's what I was on. I leave it to your lordship for 23 days behind the bar and all for this meat with the karahi it owns on 415 gram. We don't even know what it is. By now it's stale and gone. Custodial detention for this, with all humility, may not be required. Because now we are moving towards the vacation, my lord. It would come up again after a long time. I pray lordship considers this, my lord.
Produce a case study along with the FSL report on the very reopening day, that is on 13th of.
No, we
I don't think we need detention for so
Okay,
long.
I'm grateful, my lord.
Yes. Application under so and so. Application against the petitioner is that he was found cooking suspected beef inside a public institution, namely Borsola Model Hospital. The suspected meat was seized and sent for FSL examination, report of which is yet to be received. Petitioner was arrested on 31/5/26 and has now spent around 23 days in custody. Learned additional PP praise for awaiting the FSL report, although the CD is available. Regardless of the result of the FSL report, having regard to the nature of the allegation, further detention of the petitioner is considered necessary. 50,000 2 CRTs.
Great.
Objection may be recorded, lordship.
Yes, we have recorded.
Extremely grateful.
PDB sent back, lordship.
You can return it.
May I please your lordship? Lordship 483 application, my lord, before your lordship for granting regular bail to the accused, my lord, who has been in custody, my lord, for 29/5/2026, my lord. As on date, my lord, petitioner is 25 days in custody, my lord. Lordship may peruse the FIR, my lord, as page 13, relevant portion is at page 16, my lord. Total story, my lord, based on presumption, my lord. Total story based on presumption, my lord. May I read the FIR, my lord?
Yes, we have already read. Yes, what is there?
Lordship, they have made some preparation for dacoity, lordship. That is an effect. And the CDR analysis report, there's a constant communications between the associates of the entire team, lordship.
What was recovered from them?
Lordship,
That is important, my lord.
What was recovered?
they had made a preparation for committing dacoity, lordship.
No, in that, in respect of that preparation,
Lordship.
any weapon.
Stolen property has been recovered, whether
No,
any
that is
articles has
consequent
been
to the
recovered.
dacoity. How will the stolen
is-
property be there before the dacoity? It is preparation.
Lordship,
ma'am.
may I, the grounds of arrest, may I read, lordship? The arrested accused persons, namely Naren Deka, is an FIR named accused person. During the investigation, it reveals that the accused person, namely Naren Deka, along with his associates, makes preparation to commit dacoity at the residence of the informant situated near so-and-so. During investigation, credible evidence has surfaced indicating that the accused person has actively participated in planning and preparation for the proposed dacoity. During investigation, after analyzing the call detail records, it is revealed that there is prominent link between the accused person, namely Noran Deka, and other associates and driver whose phone number is yet to be collected. It has come to light that accused person and his associates had conducted reconnaissance surveillance of the targeted house a few days prior to the proposed commission of the offense. The targeted residents were occupied by the informant's aged parents, namely so-and-so, so-and-so. During interrogation, the accused person disclosed the fact that they have planning and prepared for the offense, which require further verification investigation. Lordship, from the statement of the accused themselves, Lordship, it has
Commit
come
a
into light
Gauhati, my
that
lord.
their conspiracy regarding the
Committed
committing of the
Gauhati,
crime.
my lord, my respectful submission, whether any Gauhati weapon, like my lord pistol, like my lord heavy weapon has been recovered, whether my lord, any chance if such any weapon is recovered, my lord, I am absolutely agree with your lordship that they are planning to commit Gauhati. And from the FIR itself, my lord, it is crystal clear, my lord, page 16. He received the
You don't have
information.
to agree with me. I have to agree with you.
Lordship, nothing has been recovered, my lord. Nothing has been recovered. Simply on presumption, my lord, the accused has visited his residence, my lord. On that ground, I have been arrested. Merely, my lord, I have visited near his residence,
So
my
other
lord.
than their own statements,
Yes, Lord.
nothing else is there.
Yes. Lordship, statement of the accused Narendra, may I read his statement?
That is what these are otherwise inadmissible.
Not admissible. That is a matter of trial, Lord.
That is what the Supreme Court has said. Even for the purpose of bail, you cannot consider inadmissible statements, even of co-accused.
Lordship.
Accused is straight away barred. Even co-accused is barred.
Lordship. They have made a survey of the entire house, Lordship, where the informant's parents, aged parents is residing, Lordship.
Why I
They
have,
wanted
my
to
lord, visited Paras
commit
10, page
Gauhati in
6,
the
I have
house.
explained, my lord. Why I have visited his residence, my lord. Petitioner has visited his house, my lord, for the purpose of inspection of a plot of land, my lord, for possible purchase after being informed by his friends about its availability. Mere presence of the area, my lord, cannot be constructed as participant of any criminal conspiracy, my lord. I have visited, I have admit, my lord, for
They have visited, they have surveyed the entire house. They had accordingly made preparation for committing the offense.
But simply, my lord, that submission, my lord, if any weapon for Gauhati has not been recovered, how can they, my lord, say that I have planned for
That might be
Gauhati?
concealed
Only
by
on
the person,
presumption, my lord.
Lordship. That might be concealed, Lordship.
How many days now?
Yes, Lordship.
How many days?
25 days, my lord. As of
25 days, Lordship.
The government servant.
Government servant, my lord. Station officer, fire and emergency service, my lord. Mukalma.
And who is the alleged victim?
Lordship.
Who is the alleged victim? Very rich person.
Lordship.
He is the inspector, my lord.
And
Police
he
inspector,
is
who is
supposed
work.
to commit offense in the house of.
Fire inspector will commit dacoity on police inspector.
Lordship.
That's the allegation.
The
my lord.
ailing parents residing in the said premises, Lordship.
Sounds very difficult to believe a government servant in charge, the fire station in charge is going to commit dacoity.
Considered, my lord.
Already had learned counsel for the petition and PP is an application under so and so. The guy allegation against the present petitioner is that he, in conspiracy with other co-accused persons, had made preparations to commit dacoity on the house of the parents of the informant. Where the petitioner is working as what?
Station officer, my lord.
Station
Fire
officer.
Emergency service.
Kalmua Fire and Emergency Services. And he was arrested on
29th, my lord.
Date of forwarding is 35, 2020.
29/5/2026 and forwarded on the next day. And since then, he has been behind bars. The CD as called for has been received. Submitted by learned additional PP that the CDR call records reveal frequent communication between the co-accused persons. Other than that, the petitioner also surveyed the area where the target house was located. Per contra learned Counsel for the petitioner submits that admittedly petitioner had visited the said area, but that was with a purpose of purchasing some land in the said area. However, it is not believable that a government servant holding a responsible position such as the petitioner would involve himself in such an offense. Full stop para. It further, it appears from the ID that no materials in the form of any weapons, etc., were recovered, which would indicate preparation for committing dacoity, and other than the own statements of the accused persons, there appears to be sufficient material clearly pointing towards the guilt, towards any steps taken by the petitioner towards commission of the alleged offense. Having regard to the above and the period of detention of how many? 25 days. 25 days.
25 days.
25 days. Detention of the petitioner is not considered necessary. For bail is allowed 2 years.
I am for item number 6.
Can beg the
Investigation still in progress, Lordship. Incriminating materials are yet to recover, sir. Incriminating materials in the commission of the crime is yet to recover.
Yes, we have not stopped investigation. Can beg the CD.
I am for item number 62. 62 item number.
What is 62?
Today's motion document.
Who are you now?
Lordship, in the FIR, Lordship, there is specifically names only 2 persons, Lordship. And the petitioner was arrested only on the basis of CDR analysis, Lordship. For accused statement, Lordship. And he was arrested.
Your name is not in the FIR.
Lordship, my name is not named in the FIR. In the FIR, 2 persons are named, Lordship. One Norendega, station officer, and one driver, Nawaz, Lordship. I am not named in the FIR, Lordship. As on today, Lordship, 25 days, Lordship. They are in custody, Lordship.
So only statement of co-accused.
Lordship.
The first 2 paragraphs same, hard. Then facts, part 2 same. Take any fire station session finish. Yes. That the petitioner is not an FIR named accused, and he has arrested on the basis of statement of the co-accused.
As regard to the present petitioner, I have not gone deep into the CD, Lordship, as regard.
In that case, you go and we were dictating, you should have said. Currently, he is not FIR name accused. So
That is.
other than that, definitely co-accused statement.
Yes,
has been there.
otherwise.
Other than statement of co-accused, which cannot be considered for denial of bail by the in regard to the above as well. period of detention of any again.
Deeply obliged, my lord, deeply obliged.
Yes, please, Your Lordship. Lordship, in this case, my lord, I pray for some time to get the CD updated, my lord, because it is not updated. Regarding the appearance of all the 7 petitioners, my lord.
We have appeared, my
Vacation, my lord.
Additional PP submits that updated CD is required, hence list the matter again after
On
interim order.
24th, Lordship.
First earlier to continue till the next date of listing.
Obliged. Deferred.
Please, Your Lordship.
Yes.
One calf, my lord, was stolen. Later on, Lordship, the main accused has been, as part of forwarding report, he has been arrested and recovered. Now, Lordship, in the month of March, I got interim. Thereafter, Lordship, 4 times I went to the police station. I deposited my statement, I appeared, and Lordship were fully cooperating with the investigation. Lordship.
Take specific evidence regarding that, my lord, because the note says, my lord, there is no mention of any appearance, my lord.
Yes, Lordship.
take the-
On last occasion also this question raised, and Lordship, I called him, and he instructed me that after my calling, he went to the police station, and police said that your case is over. Now what he can do, Lordship, if there is nothing, his statement is not there, and police is saying why you are come here, your case is over. Then what the client will do, Lordship?
What is there?
Take the specific instruction because that is his submission, my lord. But it is, but
No, right now no statement is there.
right now no statement is, as per the last bail objection report, there is nothing that whether he has appeared, whether he has submitted any bail application, my lord, order, nothing, my lord. So I will take the specific instruction.
From the gravity of the offense also, my lord, matter is very simple. Since March, I am on interim. 4 times I have visited police station. Even in the last week also, after my calling, that why you are not appearing. He called me back. Thereafter that I went to the police station. They are saying that your case is over. Now what he will do, my lord? This is the situation. It may be absolute, Lordship, in my submission, because the calf is also recovered. Main accused person arrested. I have annexed the forwarding report also.
Updated instruction come, my lord.
Suppose he goes there and police sends him back, what would be the record? What record will be there?
Nothing.
They'll
This is
say he
happening.
hasn't come.
This is happening, Lordship.
At least, my lord,
The Lordship,
at least some
Lordship,
proof
I
that
am
yes,
also appearing
he
in
went
court
there,
for
my-
7 times. For last 7 times, I am also
We
appearing.
know what happens there. Go in the morning, wait till the evening. Then from somewhere he comes, say, I have no time, you go come back
Yeah,
some
that
other
is
time.
also, sometimes it happens, my lord. My lord,
What was
I
the
will seek-
allegation?
I will seek a report, my lord.
Allegation was what?
Yes, my lord, allegation is regarding FIR page 10, my lord.
Lordship, may I read, Lordship? পূৰ্বক বিনীত নিবেদন এই যে যোৱা 13/1/2026 তাৰিখে গভীৰ ৰাতি আনুমানিক 2টামান বজাত তলত উল্লেখিত গাই এজনী দামুৰী গৰু গোহালিৰ পৰা কোনোবা দুৰ্বৃত্তই চুৰি কৰি লৈ যায়. This is the allegation. And Lordship, main accused,
Mr. Learned counsel for the petitioner and Mr. Learned LPP. An application for pre-arrest bail on behalf of the petitioner in connection with Abhaipuri PS case number so and so. As per the allegation, some miscreant stole one cow belonging to the informant, and in course of investigation, one Roshidul Pathan was arrested, and the basis of his statement, the present petitioner, one or two
Two petitioners, Lordship, here.
were arrested.
In that case, may I produce, my lord, what the court is to say, my lord?
No, you are not arrested. This is AB.
No, yes, Lordship, AB, Lordship. We are
As
not
per the, my
arrested.
lord,
Main accused has been arrested.
I thought, my lord, my lord, his statement will be required, my lord, but without going through the statement, the accused, my lord, who were arrested, my lord, he has confessed that, my lord, Gaore Monor Ali Urfe Osita, Tota Bhuya, Rokibul Islam Ahib, বৈঠামাৰী নিবাসী এঘৰ মানুহৰ ঘৰত সোমাই গোহালিৰ পৰা এজনী গাই গৰু চুৰ কৰি লৈ যাওঁ আৰু উক্ত গৰুকেইটা মোৰ লগৰ কেইজনমান বিক্ৰী কৰে। That is allegation is there against him, my lord. If it's on merit, my lord, arrest, my lord, granted, my lord. Subject to, my lord, considers.
Lordship,
He is what, a buyer?
He was the person who stole the my lord, goat and my lord, from
With the main accused.
main accused, my lord, as per the statement of the one of the
Lordship may kindly note one thing. Now my learned friend is saying the cow has been sold. Now Lordship may kindly peruse page number 16 of the forwarding report. The accused person has been caught red-handed with the cow. If he has sold it, how it is recovered?
Lordship, I am not saying the, I am only one part of the, my lord, statement, my lord. Lordship may kindly go to the entire statement as everything will be clear, my lord.
Yes. I have no objection. No, I am reading from the forwarding report, point number 5. Here, in the page number 16, point number 5, the accused person has been caught red-handed while killing the cow. Then when he sold the cow?
Anyway, he is implicated on the basis of your statement, statement of the main accused. Proceedul Pathan.
Lordship.
What did you write? Tested criteria. The basis of his statements, the present petitioners have been named in the forwarding report, because of which they apprehend arrests. Subsequently, it appears that it appears from the it appears from the forwarding report that the cow has been, the main accused was caught red-handed with the cow, indicating thereby that the stolen cow has been recovered. Learned additional PP submits upon perusal of the CD that as per the, I will not go into
Yes,
that.
he along with other persons, my lord, the my lord, cow for sale, my lord, thereafter this person fled and he was caught red-handed. This is
Learned additional PP submits the on perusal of the CD that the main accused person had revealed that the present petitioner was involved in the theft of the cow. This court by order dated 31/3/26 had granted interim pre-arrest bail to the petitioners. also with direction to cooperate with the investigation. However, the CD does not reveal any statement the petitioners being recorded by the IO. Para by the last order dated 18/5/2026. The petitioners were directed to appear before the IO within a period of 7 days. So it is submitted on behalf of the petitioner that the petitioners had gone to the IO, but they were told that the case was already over. Granted additional PP praise for further time to obtain instructions. When did you receive the CD?
On 16,
16/5, 5 or 6.
16/5, my lord.
Since then it has been here.
5, my lord.
Yes, Lordship, this
Then
is
order is of 18/5, then how will that statement be there?
That is the last.
Lordship, that's why
my
police
last
is
note.
saying that your case is over. This is the reason, Lordship. Now I understand, Lordship.
You understand that is for you, but we are also trying to understand what's happening.
Lordship, may kindly make it absolute, Lordship. Already 7 times I have appeared in this case, Lord.
Last order is of
However,
31/3.
however, it appears that the CD is lying with the Public Prosecutor's Office since 16/5/2026, and naturally the same would not reflect any statement that may have been recorded by the IO pursuant to the order dated 18/5/2026. He can stay, if the IO wants, he can still call him. Let us dispose of this instead of pending,
Lordship,
keeping
yes.
it pending unnecessarily.
I hereby let him appear, my lord, within some point of time. After getting the order.
Para having regard to the nature of the allegations and the fact that the stolen property has also been heard and order of interim pre-arrest bail was granted long ago. Sarah, I am not inclined to keep the matter pending any further. Accordingly, the by making absolute the order of interim pre-arrest bail dated 31/3/2026. However, it is made clear that if the IO finds it necessary to interrogate the petitioner, it shall be open for the IO to summon the petitioner and record his statement. Hence disposed of accordingly.
Deeply obliged, my lord.
May please, your lordship. There is a 482 application. The sections which have been invoked are 22C, 25, and 29 of the NDPS Act.
I'm sorry, my, this is a CD is not there, but the scan copy is there, my lord. Not very.
Yes, scan copy is there. So what is the allegation?
I don't have. Where is it, my lord?
It's charge sheeted.
Charge sheeted
Charge sheeted, my lord.
on 31/12/23.
What is this, commercial quantity or what?
Commercial quantity.
I am the registered owner here of the vehicle which was apprehended by the Naka party. And Lordship, for 6,100 numbers of codeine phosphate that was recovered from the vehicle. Now,
What is your story?
Pardon?
What is your story?
My story is that, Your Lordship, I was not knowing because I had lost control on that date. As because Your Lordship will find that I have annexed a agreement on which is at page 30. There I've stated.
You are Biswajit Biswas.
No, I'm Ratan Dev. I'm the
You are
owner
Ratan
of the
Dev.
rig. Yes. So on 5 July 2023, I had leased the vehicle to this Biswajit Biswas so that he can carry out business. He can drive the car. He can drive the truck and carry out business. So on that day, that is from 5 July 2023, I have lost control. And the incident which had taken place was on 17/8/2023. So there is no connection or connivance or no material to show to connect me to the contraband or the contraband which was apprehended in the particular vehicle. So, Your Lordship, I'll like to take Your Lordship to section 35 of the NDPS Act. That is the presumption.
ये कुछ बात है ये भी
Yes, what agreement were you referring to?
At page 30, Your Lordship. This is dated 5/7/2023. At para 2 and 3, 2 I have stated that the driver Vishwadit Vishwas, he is a resident of so and so, and I have authorized him to ply the vehicle as a driver. 3, that he is not authorized to carry explosives, substance or inflammable and illegal goods by the above mentioned vehicle. It is also particularly mentioned that in every aspect of illegal carrying, the said driver is solely liable and responsible. And the last para, that in my free consent and will, I have sworn this affidavit and also authorized to my driver to drive my vehicle anywhere in Tripura state or outside whole over India as like best, and for his identification, I affix the photographs. Be it mentioned here that if any illegal goods be carried by the driver, then he will be solely responsible for this act and the owner will not be responsible in any manner. Thereafter, the vehicle was apprehended by the NACA team on 17/8/2023. That is after a period of 43 days from this date, 5/7/2023. So by then, I have lost control of the vehicle. And secondly, on the date when the contraband was apprehended, I was not having any conscious possession.
So other than ownership, anything is there? I don't think. Conscious possession or knowingly, that something has to be there.
I have lost in the statements of the
Driver also does not say that he says, I don't know how this is come. Certainly, he is obviously not telling as far as his knowledge is concerned, because there is secret chamber.
Yes.
How will the
hiding-
driver not know about this
yes,
secret
how
chamber?
could, how could my lord driver?
But as
He's
far as owner is
hiding-
concerned,
Hiding something, my lord.
Your Lordship, another thing, this whether the secret chamber, I have manufactured it in connivance with the driver, that is also not there, or some third party. That proximity of link, that is also missing from 4/7 to 17/8/23.
My lord, there are some issues which has to be decided on at the time of trial, my lord. But now my prima facie is, as per the, my lord, since it's a commercial quantity, his vehicle has been used for transporting the drugs, my lord. Now, whether by knowingly or not knowingly, my come in the trial, my lord. A huge quantity, my lord.
Another thing, Your Lordship, as per section 37, 1B2, the court court has to be satisfied that there are reasonable grounds for believing that the petitioner is not guilty. Now, there are decisions which says that reasonable grounds means something which is more than a prima facie case. So that more than prima facie case, that has to be established by the prosecution in order to shift the burden to me.
And there is another clause also, my lord, where the receives has to record, my lord,
that he is not likely to
guilty.
commit
He is
any
not
offense.
guilty, my lord. He is not
Not
guilty.
likely to commit any
Likely
offense.
to, and he is not guilty. That is also.
That, Your Lordship, I don't have any criminal antecedents. That is also there. I've stated in my application.
okay, we'll see.
Where, like, mark anything that is.
Yes, yes.
Yeah, my lord.
Another point, Your Lordship, the codeine phosphate, which was the bottles, one bottle was containing 100 ml of the contraband substance. Now, this, as per serial notification 35 of the central government, it has stated that methyl morphine, commonly known as codeine, and ethyl morphine, and their salts including dianine, all dilutions and preparations except those which
Yes,
are.
yes, we have heard that argument and rejected it
This has
many
been
times
already
before.
settled, my lord.
So one decision is there in that line.
Yes, we have considered those decisions and rejected all of them.
This is already settled.
Yes.
Obliged. 25, this has been seated, man. Circuit number.
What is the offense?
Hello.
What is the offense?
Offense, is rape. Page 18, is a FIR.
Yes, what do you want to do?
As per direction, I have appeared before I taken bail on 13th of May 2026.
I'm not following you.
Regular.
Yeah, I already appeared before
You appeared.
yes, on 13/5/2026. Since then, I have been cooperating with the investigation.
Pay for regular bail, man.
So you can appear before the court and pray for regular bail. This is what, Master Tribal? $25. No, Sessions Tribal. So let's have the TCR then. This Sessions Tribal, even if he appears there, he appears there, he will not be granted.
Yes, yeah.
That case has been submitted by CS number, so call for the scanned copy of the TCR. Again on. Interim order passed earlier to continue.
Record call for. Record. Receive, man.
Please, Your Lordship, the conducting counsel is out of station. Your Lordship made a matter kindly be adjourned for today.
It is there, man.
It is
Let
there.
it be before vacation. vacation. Schedule.
Thursday?
Thursday.
Yes.
Ready to continue. The next date of listing.
It is there.
May I please, your lordships? Lord, this is a pre-arrest bail application, my lord, and the FIR in which we are seeking bail. My lord, may be pleased to find the allegation, my lord, is at page number 18, my lord.
What is the allegation?
Lord, allegation is
certificate.
regarding a fake certificate, my lord. Though, my lord, I have not been named in the FIR. My lord, may kindly turn to the Caesar list, my lord. The Caesar list is available is that page, my lord. From that Caesar list, my lord, my connection has come, my lord. My lord, may be pleased to kindly turn to page 29, annexure 3, my lord. My lord, this is in the Caesar list, description of the Caesar, one school certificate in the name of Sri Lakshman Kumar.
But class 9 certificate.
My lord.
Somebody requires fake certificate for class 9 also.
No, my lord. Some, and that apart, my lord, allegation is that somebody has paid rupees 20,000 to one of the accused. But in that connection, my lord, my role is not there, my lord. If somebody has manufactured a document in, my lord.
Here, my lord, as per the CD, my lord, the statements in them, you know, he has given the statement. He said that yes, my lord, he has given a certificate,
but not
of my lord, class 9 pass certificate, my lord. But he stated he has not taken any money, my lord. That
Who is he?
is the principal. No?
My lord, headmaster.
Headmaster of the school from which certificate
So he
was
is the
issued.
authority to give the certificate.
He is the authority
So
to give the
allegation is that he charged money.
money.
No, no, no. Lord, I have not taken any money,
Then
but
where is the question of fake certificate?
That will come, my lord, only after the report comes, my lord. That was
Forensic-
certificate was sent for authentication, my lord. It is pending.
But he admits he issued it.
my lord, my lord.
He is the principal, so it cannot be fake.
He said
Is
that it
it?
is not, yes, that is what it is stated.
Fake means what? It must be forged.
My lord.
So since he is admitting it is not a fake, only thing is that he is about demanding money.
Yes, তাৰ বাবে মই এখন লক্ষ্মণক ক্লাছ 9 চাৰ্টিফিকেট দিছিলো মই কোনো টকা লোৱা নাছিলো that is
I think we can remove 2 zeros. He must have taken 200 rupees. He added two more zeros there.
but
Mr. Counsel for and learned edition. This is a so and so. The petitioner is the principal of a school and the allegation is that he had issued a fake class 9 pass certificate in return for rupees 1,000 from the concerned student. Who is the informant? His student is the informant.
No, my lord, it is a third party, my lord. Some
Of the FIR has been lodged by
Puja Das, one
Yeah.
Puja Das, my lord.
third party, namely Uza Das. He has appeared in before the IO. Pursuant to interim protection granted by this court, the petition appeared before the IO and his statement has been recorded. Having regard to the nature of the allegations, the fact that his statement has been recorded, custodial interrogation of the petitioner may not be necessary. Accordingly, the prayer for pre-arrest bail is allowed. Of interim pre-arrest bail dated 11/5/26 is hereby made absolute on the conditions number 2 and 3.
My lord. Obliged.
Same like this.
May it please your lordship. Lordship, this is a pre-arrest bail application, lordship, and we filed this application apprehending the possibility of arrest in connection with any case to be registered by the Dispur police station. But till today, no case has been registered against me, lordship. Lordship, I may be allowed to withdraw this petition.
Right, very good. That's great for Mr.
C. Kolita.
Withdrawn.
Your lordship will find the FIR at page 18. Oh, sorry, it's a type copy, your lordship will look at. We give a English translation also, but vernacular is always better, my lord. And this quote,
Depends on the quality of the translation.
yes, but that's why I don't take the risk. Nowadays, I give some vernacular type copy also.
Why AI is there? Yes.
And now your lordship will kindly see the statement of the victim, my lord. There's nothing it is. It was refusal to marry. Her statement was recorded under 183.
Yes, appeared.
This is the
Yes.
statement, mother. He said that he refused to marry, but he told me that he will not marry me. He took out a blade and then gave me cuts on my left hand, due to which I had started to bleed heavily. He pushed me towards the river. Thereafter, I became unconscious.
But it is the other way around. But I refused to marry. Then she took self-inflicted injuries. And she says that she fell unconscious after that.
There are some witnesses, my lord. Says that, my lord, the injuries are self-inflicted, my lord. Some witnesses are- As per her statement,
He has appeared before the IO.
Yes, yes.
yes, my lord, he appeared and denied what is.
It had Mr. B.D. Kurlan, senior counsel.
Jury is
Dated
simple and
27/5/26.
caused by blunt of stress in nature.
Para 1, 2. Three. And an additional PP on perusal of the CD submits that the, as per the statement of the victim, the accused gave her cut injuries because of which she was bleeding from her hand.
And medical injury report says it is simple and only laceration.
However, there are also statements of other witnesses who have stated that the said injuries are self-inflicted. And moreover, as per medical report, said injuries are of a simple nature. Para pursuant to interim protection granted by this court, the petitioner has appeared before the IO and his statement has been recorded. Para having regard to the above as well as the nature of the allegations, custodial interrogation of the petitioner is not deemed necessary accordingly. Therefore, pre-arrest bail is allowed. Order of interim pre-arrest bail dated so and so is hereby made absolute on the
We are deeply aware.
conditions.
To application, lordship.
Did you receive?
Your lordship will find the affair is at page 12, lordship.
Page 8.
This is the vernacular, page 8 is the type copy, the translated copy.
Yes, PP.
He reveals, my lord, there in 183, my lord, he is implicating them, my lord, and there are some clauses that were seized from her, my lord, that is supportive of the what has been stated in the 183 and the this was stand for FSL. Now the FSL report is pending, my lord.
What was sent for FSL?
It was, my lord, cloth, my lord. It was torn from her body, my lord. Undergarments and all, my lord.
Although they made allegation for a gang rape, lordship, but the accused number 1, who at the time of commission of offense, lordship, was residing in Kuwait, lordship, and he has been in Kuwait from lordship 5/4/2026, and arrest offense has taken place on 3/5/2026. I have annexed the passport entry, lordship, the money receipt, and interestingly, on the very day of the incident, lordship, he purchased something from the departmental store in Kuwait and was issued a money receipt. And he, accused number 1, transferred some amount on the next day of the date of incident, lordship. And I have also annexed the money receipt, which substantiate that the accused number 1 not present, although they made allegation of gang rape, lordship. A totally false case, lordship. I have annexed, lordship, kindly peruse. On the last occasion also, your lordship has gone through, lordship.
Yes, we've gone through that, but we.
And the lordship, there is a lordship, there is a land dispute, lordship, and the petitioner before your lordship is looking after the land of the petition accused number 1 situated in.
Let us see the statement.
Yes. And
What?
and my lord, I'm sorry, but that clauses are, my lord, kurti, then ladies, long pant, please.
Allegation also, the accused petitioner number 1 and 2 frequently visited the home of the, used to visit the home of the petitioner victim, lordship. So because the day of prior also, lordship, they used to visit the house of the lordship victim, lordship. They are the, it is to be friend of the victim, lordship.
Still done, but the report is not there.
What you say, FSL report is not there.
Yes.
I think in this case, it is official report will be significant because medical is also not here.
And for medical, the report is not.
Yes. You have been squarely implicated in the statement very vividly, both the statements.
Yes.
So let us see. But Learned Counsel for the petitioner on an additional PP. On perusal of the CD, it appears that the official report would be necessary for a proper adjudication of the matter. Medical report is not here.
Not here.
As well as the medical report will be necessary. Hence, prosecution to produce the same on the next date fixed.
And back the CD, my lord.
Can beg the CD for resubmission on the next date. List again on reopening.
Kindly, my lord, kindly on 17, my lord. 17, my lord.
Can it be on lordship 14, lordship 70? 14. 14? He'll then some lordship, some protection lordship.
Next.
You want?
May I please, Lordship. Lordship, this is a pre-arrest bail application. Lordship will find the FIR at page 15.
Lordship, before my learned friends start, Lordship, may I submit that there was a request for bank statement, Lordship, but it was not received, Lordship.
For?
Without the bank statement, Lordship, there is some money transaction, Lordship. To that case, there will be required, Lordship.
Yes.
They have given a request to the bank manager, Lordship, for detail of the bank statement, but it is not, right now it's not available with the city, Lordship.
Offenses relating to what? Some misappropriation or?
Lordship's offense is that the accused person, Lordship, they are the worker of the company, Lordship, where they used to purchase some electrical goods, Lordship, for some contract basis, we use for contract of buildings and all, Lordship. And while taking those goods, Lordship, he used to take bribe from the company, Lordship, from the vendors, Lordship. And he make the bills double, Lordship. And the money goes directly to his wife accounts, Lordship. And some of the vendors have stated, Lordship, they used to give him bribe for giving them the contract, Lordship, for supply of those electrical goods, Lordship. So up to date CD will be required, Lordship. In this connection, bank statement is required, Lordship. Further, she may submit, Lordship.
May I? Lordship, the only allegation regarding me is that the accused number 1, who is my husband, he used to receive money in my account. But that is not in my knowledge. Neither I am involved in the proceeds of crime, Lordship. The alleged bank account is being...
Where is your husband? Is he arrested?
Yes, Lordship, already arrested on 1st of June 2026. He is in judicial custody since then. Lordship, I have a 3-year-old daughter. And if I am arrested in this case,
For the petitioner and learned.
no one should look upon the child, Lordship.
It is submitted by learned additional PP that although the CD has been received, the bank transactions in respect of the alleged offences which would be available in the bank statements are required to be examined and hence prays for some time to produce the updated CD along with the bank statements.
Turn to CD, Lordship.
Prayer is allowed there in the interim, having regard to the fact that the main accused has been arrested and the present petitioner is the wife of the main accused, into whose account certain monies were deposited, and it is said that the same was not within her knowledge, provided that in the event of her arrest shall be released on interim bail of ₹1,000 with the surety for like amount to the satisfaction of the arresting authority. Order directed that the petitioner shall appear before the IO within a period of 10 days from today for the purpose of interrogation. Please again on. So send back the CD for resubmission on the next date fixed.
Deeply obliged, Lordship.
In this case, we are appearing informant. We need to file objection. I have sent my objection for waiting Miller written. Victim Miller, that is the informant, he is under treatment, he and injuries Miller. I, etc. Miller, treatment. But now in Calcutta, under treatment in, I sent there my affidavit. File, your lordship.
My lord, my learned friend is appearing on behalf of the informant, I think, madam. He used to assist my PP, the CD already called CD receipt, as I guess, my lord, CD receipt. And if you also kindly go through the FIR itself, I don't think there is any, my lord, serious injury or anything is there from the FIR itself, my lord.
An injury report is there.
It is. Lordship, the parent.
It's a street fight actually, my lord, at 10:30 AM, PM in the night, my lord. And most of the accused
How
are
many ABs are there?
Lord, group of accused, my lord.
criminals, my lord.
1674.
Entered into my lord shop premises.
Lordship, CD
How many
is
ABs?
available.
3 ABs are there.
Yes, 3 ABs. And one is my learned friend has mentioned his regular bail, my BA. His item. It is production list, my production. He is regular bail. And one already got bail, absolute bail on the first day, my lord. And other 2 persons arrested, they released on bail on the ground it is bailable.
Yes, sir. For provocation of golden chain and looting of 2 lakhs rupees are yet to be recovered here. At crucial stage here. I have with me, my lord,
What is the name of the victim?
ODB Day, my lord.
Origit,
And he.
Two victims are there, Lordship.
Two victims.
Origit and Piku.
Then one Mujumdar.
Majumdar is my associate, Lord. In my shop.
Originally himself filed the case, madam, after 2 days.
After closing our business activities, my lord, down from the stair. Then these criminals, my lords, entered, criminally trespassed into the, my lord, yes, and started attacking me, my lord, assaulting me severely, my lord. As a result, my lord, both of them critically injured, my lord, and Piklu Majumdar, who associated, he was hospital. Thereafter, he was referred to the medical Midland Hospital in treatment. I sustained, my lord, severe injuries in eye, chest, and head. I have been referred to Calcutta, my lord. I am under treatment in.
CCTV footage photo.
Yes.
It is my case, I am to submit whether he is submitting, whether he lawsuit taken not minor. My case, I am to submit whether he is to reply.
Let my learned senior friends.
Already you have started, you have saying.
Then, my lord, I'll submit, my lord. If your lordship.
If you need time, then it is up to the court.
Yes, police claim there is CCTV footage. There is CCTV footage according to CD.
My case is, madam, you kindly see, I am for 32, 33 and 34. Kindly see, madam, FIR first, madam. What FIR says, madam.
No, what is your name? Gautam Roy.
Yes. One is Gautam Rai, item 32, and Subir Datto is 33, and Piklu Rai is 34. And my learned friend is Raju Hai. Raju Hai. He is regular billing. Now, FIR was lodged by Orijit himself, madam, one of the victims, madam. After 2 days. What FIR says, madam, police covered, madam, night covered, they have taken to them to hospital. No entry, nothing is there, no treatment, taken to civil hospital. Then you have taken to Shilchar Mediland. Yes, private hospital, man. And so far this madam Gautam Rai is concerned, your lordship will find, he is actually, madam, 61 years, NGO plus, I have given all the certificate. Yes.
Page 17.
Yes. Yes,
Of course, madam, from the FIR itself, it says a group of criminals, madam. 10:30 PM, 10 to 11 PM, madam. Group of criminals. We have no entries that are very good, madam. We have no involvement at all in the criminals. Two of them, my lord, one has gone to purchase medicine at the night, madam, 10:30. While coming back, he heard that, my lord, this group class is going on. He just went, he came back. Two other persons, my lord, one person was called by one of the, my lord, accused, whose father has, my lord, taken my help to take him to the spot, my lord. I have just used my bike and I have done subsequently. And other persons, my lord, so far this Gautam, he is, my lord, his distance relatives are involved, so police is after him, my lord. None of them, my lord, so far my information, these three persons, they are not participating in the occurrence. By coincidence, they are there, my lord, they have gone there.
Who is this? There is a Piku and Subir Datta, Gautam Roy, Piklu Roy.
Yes, my lord.
And who is this Raj Roy?
Raj Roy, my lord, friend, my lord, arrested.
I am appeal for Raju. And no objection is raised against me by the. I was not there. I am a driver.
Objection only with respect to, my lord, Piklu and Gautam. Huh?
If it was not filed against
He
me.
is delivering, my lord, developing his story. Last time also he said, my lord, when the matter came, the other day. Yes, my lord, on 17, my lord.
Raj has come, I
Like and Subid.
The lordship will see, and so far the Gautam Rai is concerned, my lord. Page 17. Is my lord, NGO plus A, and angiography, my lord, page 17, I have given a certificate, my lord. Till he is, my lord, undergoing treatment. Regular medicine he is to take, my lord. So far, item 34 is concerned, bypass surgery is there, my lord. That we have annexed everything.
All right, we have heard, so
It shows, my lord, he was there. Indian petitioners, they were there and they assaulted the accused person, the informant, my lord, which is associates. The result, they sustained their injuries, my lord, they are. You can report my learned has submitted before. This gold chain, my lord, also snatched away. Rupees lakhs has been looted, my lord. So my lord, there is a clear intention to harm him, even to, my lord, they attempt to kill him. Therefore, my respectful submission. Here, my lord, custodial, therefore,
He has nothing to do.
that, my lord, bail petition make.
My lord, only one point, my lord. Whether any specific education against anybody, specific education, my lord. Yes, even in forwarding board also it is not there, my lord. Specific education. And what I can say, my lord, actually the PP is to submit. He is to assist the PP. But he is taking the show, my lord, PP is silent.
Lordship,
PP is speaking through the CD.
No, that's up to your lordship, my lord.
Submit-
Yes,
Lordship, it is admitted fact, Lordship.
yes, admitted fact, okay, I am not denying, my lord.
Their Lordship, and two witness, Lordship. One is Lordship Pinaki Pani or Pinaki, or
Pinaki?
one Lordship Nantu, who have given shelter to, Nantu have given shelter to Raj Roy, who is inside the bar. And this Pinaki Pani have given shelter to, I think, Gautam,
They are already released, arrested and released, my lord.
Gautam Roy. And due to the alteration, that the altercation took place, Lordship, and Lordship may peruse, the accused have admitted, Lordship.
Yes,
They
we are
felt
not denying,
insulted.
my lord. Occurrence took place.
While they were in the market, Lordship, they have, the victim have said something, for that they, as they were locals, they get insulted and they have started. And they have admitted that they have give him a fist blow and assaulted him. And Lordship, there is a witness of injured victim is also there, Lordship, who is the complainant. He there. I have flagged it, Lordship.
Yes, we'll see.
May I plead your lordship for bail application 1674, 2026. I am behind,
How long?
I am behind the bar for 28 days. And my name is Raj Roy. Important thing is that, most important thing, if you go by dates, that particular occurrence took place in 16th of May 2026. They are saying that eye injury is there, but victim himself went to the police station on 18th of May and filed this particular FIR. Now, after 2 days. Now the point is that, most importantly, according to FIR, police rescued him and took him to the hospital. Hospital released him. And police did not do any suo action because the fight was a simple street fight. Just because Arijit De was a very influential rich man. I am a driver. It's all these things happens in a particular mohalla. We live in a same place. Origin, the building was actually, that building was actually Kolkata Bazaar is there. Origin, there was the owner of that building. His shop was not there. He resided in Calcutta. My submission is that I am behind the bar for 28 days. I am sure nothing is there in the city against me because I was there on the CCTV footage just protecting all these things because all these people are from same locality. And it was a sudden fight because most probably both the parties were consuming alcohol at that time. That is the story. Small story has been made big because that Arijit Roy is a very big man of that particular locality. But I am behind the bar for last 28 days. My
So he should also be put behind bar.
Lordship, it is Raj Roy, Lordship. He have admitted.
yes,
He went while he have got
yes.
the news over telephone, Lordship. Then he went there and he also helped in assaulting the victims. Lordship.
Now the
He's
problem is I have admitted that I am there. But I am behind the bar for 28 days.
Yes, I think we have heard enough anyway. We have reserved. all-
Lordship,
Yes,
city is Lordship.
yes, next item.
My case should be considered, considering the
Story, my lord. Snatching gold chain, looting lakhs rupees is a small story for him, my lord.
Obliged to.
করতো এটাই আছে নাকি একেলগে I think same.
Same. Same.
Same, my lord, same. Yes.
Three petitioners, my lord. Same as all. Same FIR.
Same, all the coincidence, my lord, their presence.
But 4 cases.
Yes,
Four cases, Lord.
4
Alternate.
cases. We are for 332.
So yours
33,
is in
33.
this list. Oh,
Right.
production list is there.
What?
Production is the reason.
Obliged.
I'm obliged. my lord. Four.
In this case, my lord, counsel from the side of CBI has filed affidavit whether it is stacked or not. The record.
I don't think so.
Yesterday we have filed your notes.
Senate Standing Council CBI submits that an affidavit has been filed on 22nd. Registry is directed to take the same with the record and place the matter. When
Possible, my lord, before vacation.
if not possible, after vacation.
This is the natural consequence.
It is a bit after vacation, then too many, I think, vacation.
Much obliged.
Yeah, please, your lordship. Survey completed, so there may be listed for him.
Hard learned counsel, petitioner. Anybody appearing? No. Here has been received. Service is also complete. Hence, is the matter for hearing on given it.
Obliged.
Your Lordship, in this matter, service is completed and TCR has been received. Lordship, matter may be fixed for hearing.
Third learned counsel, PCR has been received. Service is also complete. List the matter for hearing on.
Obliged, your Lordship.
38.
May I please, Your Lordship?
We listed for hearing.
Fine.
It is long listed for orders. List the matter for hearing on.
I look.
I think the matter is longly listed in the orders column. It is already fixed for hearing. Both the matters.
940, same order, wrongly listed for hearing, but orders list for hearing on given date.
It is in the
23.
Okay, highly appreciated.
Basically, record has not been received and service ID card on respond number 2 and 3 has not been received. It has not been returned back. So, my lord, I may be allowed to take fresh step on respond number 2 and 3.
PCR not received, service also not complete on respondent number 2 and 3. Petitioner to take fresh steps on 2 and 3.
My lord.
Lordship, I'm for respondent number 1.
So and so appears for respondent number 1.
Lordship, as per order 2/1/23, the appeal is admitted subject to deposit of 20% of the awarded amount before the
25.
registry. Awarded amount is not deposited, Your Honor.
So it is not admitted.
My lord, I shall take instruction on it. I have to take instruction.
Learned counsel for the appellant will also take instructions regarding deposit of the statutory amount. Please take it on.
Bless.
May I please? As per office noted 12/6/2026, service upon respondent number 2 has been received back with process server remark as the date of appeal is expired. We'll take fresh steps on respondent 2. As regards respondent 1, my lord, service is awaited.
Service in respect of respondent number 1 is awaited. Petitioner to take fresh steps on for service of notice on respondents number
2.
List again after on.
Lovely.
Lordship, probably the matter was directed to be listed as admission, my lord. Because entire we have by this criminal petition, my lord, we have wait for quashing of the FIR. Subsequently, charge sheet has been filed, which has been put to challenge by way of my lord this IA. The entire matter can be disposed of at stage. Or if your lordship want to hear it, I can make myself.
Even disposal, it will have to go after vacation.
So I am for respondent number 1. I have submitted my reply.
Already heard learned counsel for the petitioner, counsel for respondent 2. It is submitted that reply has already been submitted on behalf of respondent number 2. Any TCR required?
TCR has already come.
TCR has already been received and list the matter for
admission column.
Admission on given date on vacation.
Published.
Well, can it be on 24? Yes. I'm obliged.
Published. Team Lordship, she would ask me whether the WhatsApp screenshot is there. It is not there, Lordship. Along with the screenshot of the WhatsApp.
My lord, this is the entire case diary, my lord. If it is there, it will be there, my lord. And I,
Their lordship.
my lord, I have obtained instruction, they have not
The-
received, my lord.
Mandatory period is not yet over, lordship. It's a commercial quantity. We have got time, lordship.
Right.
That is not, my lord, only
is
thing is,
because it is-
now, my lord,
For the petition,
At the same
an
time-
additional PP.
lordship may
Upon
submit.
perusal of the CD, it is seen that the WhatsApp, that the notice under section 48 said to have been sent by WhatsApp message to the relative of the accused Zahidul Islam Bhuya is available in the CD. Additional PP is for submission of the updated CD containing the aforesaid notice stroke message. This is the matter. Reopening.
Reopening, lordship, on the very reopening.
Yes.
Lordship, there is a series, Lordship. 55 to.
Item, the series of ED.
Lordship, in this case, I have no copies has been received by Defense Counsel, but it is not being listed, Lordship. Again, not being.
Where is it list for others today?
He has filed an interlocutory application asking for vacating of the stay order, which has been made as by the Honorable Court as signed that till Supreme Court has come from the Supreme Court.
Obulapuram.
This will not be possible before vacation.
It be on.
We have too many matters pending for.
That will be in the first week of August.
Wait. Which from 45 to?
58. 12 list on a
5 to 58.
23rd July.
The prayer of learned counsel for the parties list the matter again on.
Any day in the first week of August.
Give a date.
Fourth.
4 hours. And
But
during just
interim
that,
order-
Lordship, they will file reply.
Let us first, all the things should be sorted out. Your case are not coming.
No, I provided the copy, but it is not being listed due to some, maybe some due to.
Sort this out in the meantime, we have time.
You sort it out first, na?
And
We'll come on the fourth, madam.
Lordship.
Achha.
Stay order to be extended.
Yes.
Order
Similar order in all the cases.
need to be, stands extended till the next date of listing. Same order all cases.
Actually, it's signed by the court, it is made. Actually, stay order itself is operating endlessly.
My lord, with regard to item number 65, my lord, there is an interim order that may be possible. Item number 65 orders, my lord.
What?
There is an interim order that may be continued.
65.
Okay, I'm sorry, my lord, I'm sorry.
I've got the order, madam. Madam.
This was AB. Oh, this is also AB.
AB, madam. I have also taken the same plea, my lord, page 7, my lord. The CCTV.
How come all of you have CCTVs?
Page 7, paragraph 9, madam.
Your CCTV footage is at the place of occurrence.
Yes.
In this case, it was different. It was his own place as a form of alibi.
Fine. And in fact, my lord, I have also filed one FIR, my lord, cross FIR, my lord, which was also registered as wrong in a PS case number 144, my lord. That FIR was suo moto filed by.
Cross FIR is not cross, it's by police.
Police, suo moto, my lord.
This maybe 1326, okay. Mr. NJ. Learned Counsel. There are three. It also appears that suo moto police case was registered as Rongya PS case number 144 of 2026. Which also discloses involvement of the members of the informants group. Good stuff. The CD in respect of another PRS bail application being AB 1326 of 2026 been called for, and the said case is fixed on 28/7/2026, wherein the petitioner therein Salamun Khan had been granted privilege of interim pre-arrest bail, having regard to the above. Call for the case diary. Okay. Rest is same after call for the case diary.
Fix the matter on the lordship.
Same date, list the matter again on 28/7/26 along with AB 1326 of 2026.
I have to appear before the IO, my lord, with
Yes, yes. 10 days.
10 days.
Maybe recorded.
I'm obliged.
Obliged.
Wait, please, your lordship. Well, this is a matter in which we have suffered an ex parte judgment and decree for 3.5 crores. But I'm a company registered in Delhi. I'm in the business of publishing books. But I enter into several contracts with a Lands Periodicals, which is a company, local company here. There were some disputes that took place. Thereafter, what happened was I was constrained to issue a legal notice saying that there is a vast discrepancy. You have been cancelling my contracts. You have been doing all kinds of things. We need a chartered accountant to look into what is our financial position. You owe 18 lakhs to me. When the legal notice was issued, without my knowledge, a suit was filed here, a title suit, not a commercial court under the Commercial Courts Act. And if the proceeding was going on and summons were issued through postal AD millets. Meanwhile, I was in Delhi under the MSME Act for resolution of this matter through an arbitration proceeding under the MSME Act. I was not aware of anything that was taking place with respect to the suit that was filed here. In response, no reply was filed to my legal notice. Simply they went and filed a suit. Now, Millard, at some point in the MSME, I'll show all of this to your lordship. I won't take much time if there's a shortage of time. Millard, I'm responsible. Just a moment.
Your lordships.
Just a moment.
Before proceeding, your lordships, the appellant has filed an additional affidavit. And
That's what we have heard. He's just giving a brief.
Yes, Millard. Now, kindly see, Millard. They came and filed in response to this MSME arbitration, saying a suit is already filed in Gauhati. Therefore, this MSME proceedings cannot go on. The matter is sub judice there. There is no question of any arbitration proceeding any further here. That is for the first time that I came to know that there was there is a proceeding going on. Within a span of few days, 3.5 crores ex parte judgment and order was given. Well, may I just invite your lordship attention to a few pages? I won't take. I've come all the way from Delhi. The legal notice is 163 minutes. Your lordship sees page 163 of please sit down. You can assist me. May 16, 2023. This is the origin of the dispute I have asked. And kindly see at para 8b. Kindly see at para 8 on 165. Considering land period disregard of my client's intellectual property rights, contractual rights, common law rights, and applicable laws, it would be well within my client's right to initiate immediate legal action against lands periodicals. However, prior to initiating legal proceeding, my client wishes to give you an opportunity to make right the damage caused due to sudden termination of contracts and non-payment of dues owed to my client as per mutually agreed contracts. In view of the aforesaid, my client hereby calls upon you to comply within 7 business days. Millard, kindly see B in this. Submit to a third-party audit to determine the extent of my client's damage and losses due to gross violations of the said intellectual property infringements of our projects in any manner whatsoever. No, Millard, this is the beginning of my dispute. Subsequently, the suit was filed here. Thereafter, I tried to go, because there is no response to my legal notice, I go under the MSME Act in Delhi, and there I say, let this be arbitrated, my dispute with them. Millard, in the arbitration, they have mentioned this, and I'll show that page to you. Lordship sees page 176. Page 176, Millard, your lordship sees. Kindly see page 170. Millard, this is, sir, with reference to subject cited above, the Council for Lands Bureau would like to state the following facts for your consideration. Millard, this is when your lordship sees subject reference number DAC MSME of 17924. Kindly see, Millard, they are sending an email. The Council for Lands Periodical sending an email to MSME. That Sri Deepak has been appointed as arbitrator in case reference so-and-so. We are interactive with land periodical. This also I have instituted prior. At para 4, Millard, your lordship sees that lands periodical has already approached the jurisdictional court at Gauhati with regard to the same issue covered by the reference number so-and-so. This is for the first time I come to know. Now, Millard, may I just invite your lordship to the cause title of the suit filed by my learned friend, title suit at page 28. 28 minutes, kindly see.
Before elaborate your lordship hearing, the copy furnished to me, your lordships, is not the concise copy and not eligible, your lordships. Tomorrow they submitted the memo appeal and document.
Yeah, let your lordship may.
No, please. Let there be something, your lordship. This is the copy. How can I go through and how can I read, your lordship? Even the my learned friend referring the document, your lordship, it is not as per the reference made by the learned friend, your lordships. and moreover, your lordship, this affidavit file, tomorrow I received, your lordship.
Your lordship heard.
Lordships. And he brought the facts, your lordship. Expertise degree. He brought the fact by.
I'm the appellant here.
My learned friend not there. No. Whatever you say.
I will expose all the malafide.
Whatever you saying is the fact which ought to have been pleaded before the trial court. They have not pleaded anything, your lordships.
The affidavit filed.
Millard, he is interrupting
reading
me,
his
he is
facts
not
will-
allowing
these
me
are-
to
these
complete
all
my
facts-
arguments.
These facts can be taken into consideration, your lordships.
He will hear your lordship.
You don't have any WS before the trial. court.
Millard, kindly see.
How
Millard.
can you bring all these
Well,
documents?
just a moment, Millard, kindly.
Brings.
Millard, he has heard you. Allow me to complete, Millard. Kindly, kindly.
You are
see-
not submitted proper.
Millard, this is filibuster cannot help him win his case. He has
You
to.
have to
He has to.
fairly give me the copy. Why
Millard,
you are not giving fairly the copy?
Millard,
Tomorrow you
Millard,
give
if
the
your
copy.
lordship, Millard, if your lordship, he wants to obstruct
Ultimately,
your
what
lordship from passing any order, I have no problem. Let
Ultimately,
him
what
try to do
happened
it.
in that suit, ultimately you entered appearance.
Yes, Millard. What we
Contested.
did is kindly see. Millard, just one moment, just one moment. I'll come to the point. Kindly see page 28 is the cause title. Cause title is his suit, and now the versus Weaver-Bird Interactive, sector 30. The address is A1 Nithari Road on page 29, sector 30, Noida. Right, Millard? And then the two, this thing, Weaver-Bird Interactive having this address office Nithari Road. Millard, I am the prime and chief executive of Weaver-Bird. The address and the address of the Weaver-Bird itself is the same address. And as per GST records, we had shifted from the address, and they were able to get an ex parte order against me, and which the learned judge erroneously dismisses even before the judgment it came. Now, Millard, on 1/10/24, or before that 27/9/24, I came to this court after seeing what I just showed your lordship, that email, that kindly don't proceed against me ex parte. I have come to know by the email sent by the council to MSME that they have filed some case, and therefore kindly allow me to present my case before your lordships. Millard, now the question is, I will persuade your lordships completely that my address was changed. I was wrongfully treated as an ex parte, and therefore I could not place my case, and therefore 3.5 crores is not a small amount, Millard. Your lordship sees how important these are. They filed a title suit because, Millard, I'll tell your lordship, in a commercial suit, what happens is a pre-litigation mediation is mandatory. So they don't want the pre-litigation mediation, mandatory pre-litigation mediation. They want to treat me ex parte by sending it to a wrong address, and therefore have such a judgment in their favor against me. Now, this is the long and short of the case, Millard. If your lordship wants me to go on for another few minutes, I can here itself satisfy your lordships that I have been proceeded wrongfully ex parte, Millard, and I have to suffer a 3.5 crores ex parte judgment and decree, Millard. And I'll also give your lordship a case law. I have prepared a full note on how ex parte judgments and ex parte proceedings have to be carried on, right from the apex court to many high courts, and which your lordship will agree, having seen many such matters. Now, question here is, Millard, the point here is my learned friend, and I would like to address what he has said, that his copies are not legible here. He is saying that additional affidavit is, he wants to file reply. I have no objection with that. But Millard, he has filed an execution petition. Now that execution petition, they will proceed against me. Let your lordship, let your lordship say that they subject to the, I have my IAS 570, subject to the hearing of that IAS 570 for stay and other reliefs, the execution proceedings may be taken up later. That's all. I'm not going to oppose my learned friend's objections. Let him address your court after I have addressed, because I have just briefly given you, because he is constantly obstructing me that I should not go on any further before your lordship, because he doesn't have legible copies, or if he wants to file a reply, etc. I have no quarrel with that. But the execution, then your lordship may protect me. Let that execution petition be taken up after your lordship's order on my IA for stay.
Please, your lordships, what my learned senior friend has submitting before your lordships is the matter order 9 rule 13, your lordships. He ought to have been filed a order 9 rule 13 application for setting aside the ex parte degree.
But I've even challenged it on
the
merit.
procedural lapses he is saying.
He has both the options.
This is the
If
option.
it is actually an ex parte degree, he could have, but he has the option to challenge on merit also.
He can challenge you, but he can challenge. There is no dispute. He can challenge on merit, your lordships. But the procedure he is saying that the address is wrong and all these, your lordship, has to be go order 9 rule 13, your lordships. And facts is brought before this, your lordship. Your lordship cannot be entertained, because
until unless ex parte degree is vacated, his WS on record, your lordship. How can this fact can be pleaded before the appellate court, your lordship?
I'll argue on merits also.
Limited things which he can do is the show the illegality of the judgment. Otherwise, his fact cannot come, your lordship, for education of this appeal, your lordship. And my learned friend already submitted that he filed an application for vacating the ex parte order, and that was rejected, your lordship. What prevented him to come before the simple court under 227, your lordship, for assailing that order? He has not done this also, your lordship. So now bringing all these facts that the someone was not properly served, the case is proceeded wrongly, all this is not material, your lordship, because he participated in the trial. And furthermore, my humble submission, your lordship.
I was
Further, my humble submission, your lordship.
I didn't participate in the trial. No.
You
110, Millet, may I show the order by which I have been ousted? 110, the lordship may say page number.
Please, your lordship.
110, my order is.
I have memo appeal served to me, your lordship. Please kindly be taken. Memo appeal I have given to your lordships. Ineligible. All these documents my learned friend is referring is not there. Not eligible. Tomorrow he submitted given to me, your lordship. How can I? Tomorrow. Your lordship, tomorrow. Yesterday. Sorry, yesterday. Eligibles.
All right.
And
What you have to serve him the copy.
Millet, no, without Millet, I will give my learned friend a fair opportunity to advance his case. Millet, I should also get that fair opportunity, Millet. And Millet, this is not a small matter. This is a very, very serious matter in the manner in which he has done forum shopping, a matter that's supposed to have gone to a commercial court. And allow me to complete. Millet, allow me to.
Shopping, hot melon is saying.
No, but kindly, Millet, allow me to complete, Millet. Millet, when in a matter.
Wrong allegations.
Millet, my submission is that this should not have been a title suit, should have been a proceeding under the Commercial Courts Act, where there was mandatory pre-litigation mediation is
the merit of the appeal.
Kindly see, now at the very threshold, the proceeding went wrong. Thereafter, they were treating me ex parte so that I don't get an opportunity to defend myself in the matter. I have filed that additional affidavit which shows by a chartered accountant. Millet, can I invite your attention? Just one more.
There is no point going on and on. Because you will say something, he will again get into this.
I am bound by your lordship's direction. I can only persuade your lordship that we have an excellent case. Millet, but just one last submission. The amount they paid me was 1 crore 22 lakhs. The amount they're claiming back after taking everything is 3 crore 550 lakhs. Can you believe it? Millet, your lordship will believe it?
Don't know nothing to believe or disbelieve. Because
I can show it from the papers as well. If your lordship has some few minutes, I can persuade your lordship that this is completely an abuse of process of court and malafide proceedings that they have carried out.
what is the point of all this today?
No,
Since
yes.
You will anyway have to repeat everything
Yes,
on the next occasion.
sorry, Millet. I stop here.
Anyway, you have preferred this appeal. You need to serve a legible copy of the memo of appeal. And since you are praying for stay, you have filed an IA. So you will obviously be filing an objection. Okay. So give us a date within which we can complete all this.
Sometime in August, your lordship may take it, give it up in August.
Heard, Mr. You're Mr.
Dr. G.V. Rao, Millet.
G.V. Rao.
V for victory.
So and so. This is and Mr. Learned Counsel appearing for the sole respondent.
Respondent, yours.
This RFA has been referred against the judgment and decree dated so and so passed by the so and so. Admit the copy of the memo of appeal be served upon the learned counsel for the respondent within a week. Call for the TCR. Please the matter again. Give a date.
Let's, 14th August, 14th August. Well, the only question is, well, that execution petition.
Yes, we'll take up the, there is a delay continuation also, that is done.
Already put down.
Delay
Well, only there you may say, your lordship may say something that should not be
No,
pressed, or
your
it
lordship-
it should be taken up after.
That it is a money degree, your lordship, let
No,
him
no.
give the 50% of the.
No, but that is not.
Yeah, this is the thing.
Millard, it's an
If
expert.
we want to stay, then
IA
50%.
number 570 of 2025. Heard learned counsel for the applicant. This IA has been preferred, seeking stay of the impugned judgment and execution of the impugned judgment and decree. Learned counsel appearing for the respondent submits that respondent would be filing objection to the therefore stay of the execution will be considered upon receipt of the
Very well.
TCR and please take it on same date.
Same date. Much obliged. I'm grateful to you. Much obliged.
TCR receipt is not tallied with this case, man. It's a different TCR.
Yes, my lord. It's a, my lord, case of, my lord, Karimganj 250. But my concerned case is, my lord, our Ratabari PS case. Kindly see the next page, in the record, my second page.
Okay, if you say it is
Much.
not done, what is it?
DPS case number 29/26. It is 60/25.
Sixty of 25.
Ours is 29/26.
Same
So
60.
wrong record has been called for, it seems. How? Order sheet, office note shows 60 of 25. Did you mention somewhere?
Oh, my lord, my
Wrongly.
submission is 29/26. It is on record, in my record, my lord. My petition, my lord, 29/26.
Right. Appears that the wrong TCR has been sent. As the present bail application is concerned with NDPS case number
Yes, my lord. 29/26. Special NDPS case number 29/26.
26 pending before the court of the
Special Judge Sribhumi.
special judge NDPS Ribhumi. Whereas as per office note, the case record of NDPS case number 60 of 2025 has been received by the registry. Registry to call for the case records of special NDPS 29 of 2026 from the concerned court. Scan case records, okay. The matter again on
Obliged.
May it please your lordship. Your lordship, this matter has come up for the first time. I is for continuation on delay, your lordship.
what is the delay?
Delay of 237 filing the appeal.
Any objection filed?
Yes, your lordship. I pray for some time to file our objection. I am appearing for respondent number 1.
There are 2 more respondents, your lordship.
They've been served.
No, your lordship. It has come up for the first time.
Okay. Which one is condonation? 2144.
2144.
Third learned counsel for the applicant. Application for condonation of delay in preferring the connected appeal. So and so appears for respondent number 1 and prays for time to file objection. Prayer is allowed, issue notice to the remaining respondents by speed post with AD within 3 days.
I have not yet received a copy, sir.
A copy of the application and will be furnished to learned counsel for respondent number. List again on.
Of the extension.
Please, Your Lordship.
May it please, Your Lordship. F is FAO against interim order of the Waqf board. Waqf tribunal, Lordship. Order is at page. Lordship, kindly take up the IA.
Yes.
Part of the impugn order at page 88. Lordship.
Yes, what is this?
By this order, an interim injunction was granted against the petitioner, the effect of which is of the final, like a final decree. See the second paragraph. In the result, an order of an interim injunction is granted in favor of the petitioner and the opposite party. Their agents, executors, assigns, representatives, etc. are restrained from trespassing, entering, and thereafter carrying out any form of business from the schedule and without entering into an agreement with the petitioner till the next day. Now, Your Lordship may see the schedule on which the injunction was granted. It is at page 24.
This application is for has been filed with a prayer to stay this interim order.
Yes, Lord.
Family Summit, Lordship. Lordship, I just my praise, Lordship. Lordship, I mean, this is a application is filed against an ad interim injunction order, Lordship. And both the parties are already appeared before the trial court. And this honorable court has already decided in the first day itself that it will not stop the proceeding before the trial court. Since the trial court matter is already pending, there all the documents are ready. Let them appear before the trial court, file their written objection, and the injunction, final injunction order maybe, because this is an ad interim injunction that was, if your Lordship will go through the order, it was only appointed till the next date. So, Lordship, let the trial court decide if they are means not aggrieved by the final injunction order, they will very well proceed before this honorable court, Your Lordship. But at this stage, this is an ad interim injunction, and the party suit is proceeding, Lordship, and they have not yet filed a written statement and their written objection before the trial court, Lordship. So let them file a written statement, written objection on the very next court may fix a time limit within 15 days. The injunction application should be disposed of, Lordship. This proceeding before when the trial court proceeding is not stayed, Lordship, so it is an unnecessary.
Not unnecessary, Lordship.
I'm saying if
Lordship will find it. Lordship will kindly see page 24, the schedule. It is a case where the plaintiff are not the actual owner of a property, but they have obtained injunction over the property belongs to the government.
See, this interim order, ad interim order was till the next date. That is 5/6/26.
They have passing, the tribunal has been passing different orders insisting the police to go for enforcing this order.
That was prior to before filing this FAO, when there was an injunction violation. Trial court, we filed an application for violation of injunction application for enforcement of the order, injunction order also. In terms of that, an order was passed. However, when this honorable court has directed us to maintain status quo as regards not to take coercive action against the petitioners, no steps has been taken, Lordship. So we can maintain, Lordship can very well reflect this on the order itself while disposing of this application, that no coercive actions will be taken until the disposal of the final injunction application, Lordship. We have no objection to that, Lordship.
Coercive action against whom?
The petitioner, Lordship. And out of this, Lordship.
Who are you? Who are you actually? What are you doing?
Lordship, I am.
The petitioners.
They are hawkers, Lordship.
Hawkers.
Lordship, here is a road in the Bhangagor area. It is called Masjid Gully. It is by the side of the Bhangagor overbridge. There we are running. We are the street vendor, Lordship, in that area, and this person, he has his property just opposite to our vending places. That a big building is there. It is work of property. Now this work of property falls under Gauhati Revenue Circle, but the road where we are sitting, it falls under Dispute Revenue Circle. This person is not the owner of that road. It is a public road. It is government road, Lordship. Now what happens? There is an order. They have obtained an order from GMC to run a daily market in their private property, covered under DAG and Pata number. This GMC order does not cover this road. These persons are running their business since 30-40 years back. Now, by virtue of the GMC settlement, this person filed a case before the Waqf Tribunal and obtained an ad interim order, whereby the tribunal have directed us to enter into an agreement with that person. If we enter into agreement with that person, then it will give the effect that I have accepted his ownership over the over the government land also. By this way, Lordship, he is trying to persuade us to enter into agreement.
So, as against an ad interim injunction order, you are required to file your objection.
Against that I shall file, but this order, on the basis of that he is insisting to enter into an agreement, that he cannot do, Lordship, because it is a government land. Your Lordship will find.
No, he can't force you to enter into an agreement, but you can get this order varied.
That's it. That's all. Yeah.
They cannot force
That
us.
is where you should have first.
We shall file our objection and written statement also.
They are not inclined to file a written statement or written objection before trial court, Lordship. Even on the last 2 consecutive dates, they have not even filed adjournment petition before the trial court, Lordship. That may be brought on if they have. I am speaking in if my statement has any falsity, they can say that before this honorable court, Lordship.
If that is so, I can produce the order sheet of the court, how it is proceeded. Because the tribunal does not pass the order on the same day, Lordship, it passed subsequently. Therefore, we do not have any option to appear in the case also. Lordship, your Lordship may take up today's affidavit, Lordship. I have filed it today. It is 2 reports of the circle officer.
The disputed facts, Lordship, that will be determined by the trial court. If it is his road does not fall within my patta land, Lordship, then very well this injunction will go, Lordship. My suit will become
obtained by virtue of this honorable court's order, Lordship. Page number 116 of today's affidavit.
Just 1 moment. Yes. What about, what additional affidavit?
Just filed today, Lordship.
Yes,
Start
what do
from
you want
page
to bring on
100.
record by this? What do you want to bring on record?
Lordship, there is two reports of the Circle Officer Gauhati and Circle Officer Disputed Revenue Circle. Page 114 is my application to the Circle Officer Gauhati Revenue Circle, and on the basis of this application, at page 116, it was submitted. First, I come to page 115, the last para, my prayer in the application. Hence, considering the aforesaid factions, it is most humbly prayed that your good office may cause a field verification of the aforesaid road in question, that is Masjid Gully, and provide the information whether the road, namely Masjid Gully, is a PWD GMC government road or a private road, along with the other 11 revenue details of the road as per the land record, and also provide 11 documents including Jamabandi, trace map, etc. with regard to the said road, and for which the undersigned shall remain ever grateful. Now the report is come at the next phase. With reference to the subject cited above, and in response to your letter under reference, I am informed you that the road in question, that is Masjid Gully Bhangagar, does not fall under the jurisdiction of this revenue circle. Accordingly, the required information could not be furnished. Then the next application was made to the Circle Office dispute. The report is at page 121. In reference to the matter cited above, it is respectfully submitted that as per the Honorable Gauhati High Court order dated 8/6/2026, asked to furnish the report of the road of Masjid Gully Bhangagar, the undersigned submit the following report as under. That as per the land record available in this office and as per the LRA staff report, it is seen that land covered by government Dag number 2675 under Beltola Moja is Sorkari government land and is remain in the remark column, it is recorded as road. Now that is a road and government road. Now if your lordship see the page 24, the schedule.
So this is the report is in respect of the place where you were having your stalls.
Yes, yes. And that is why I am asking to see your lordship the schedule. They have brought this road also as their own property. They have mentioned it in the schedule. I am reading a plot of land measuring 4, it is at page 24.
124.
Only 24.
Of the appeal.
In the IA.
Yes.
A plot of land measuring 4 kotha 10 lesa, which encompasses a private pathway, popularly called Masjid Gully, and the land beside is covered by Dag number 1654, Patta number 585, village Ulubari, Moja Ulubari, Circle Gauhati, district Kampung Metro Assam. Now they have given the Jamabandi of this land also, but they are claiming that this Masjid Gully is also under Dag number 1654, Patta number 585. But the Gauhati Circle has clearly stated that this road does not fall under Gauhati Circle itself. So what they are claiming that this Masjid Gully belongs to them is absolutely false. They have misguiding the court and obtained the interim order. Therefore, my prayer is that the interim order may be set aside. We shall file our objection. Court may decide the matter on for hearing us. It falls under the dispute circle office and it is a road also, government road, not belong to any walk-up property.
Humbly submit lordship. This case.
Yes, you will. Let him finish. If he is finished, you can submit.
Here is a, I have annex Sita copy also at page 27. Page 126 is the English translation, 25 and 26. The land Dag number is 12675, the extreme left, and Patada's name is written as government.
Yes.
I have annexed some geotech photo also.
You will not go to that length.
Yes, yes.
At least stage.
The thing is that it is clear from the report of circle officer also that this property does not belong to Waqf board. It is a government. Therefore, they cannot get any injunction order restraining us from entering that property. Therefore, the impugned order is illegal and it may be set aside. Reply to him after my landed friend.
Lordship comes to the I that my friend has filed, Lordship. Page number 28, Lordship. Petitioner, plaintiff, who is the respondent here in Lordship, is in Waqf estate in the name of Anwaruddin Waqf estate, Lordship. So if a Lordship comes to Jamamandi, the Jamamandi where patta number is 585 and the disputed dag is 1654, Lordship. So it is the very reflected Syed Anwaruddin Waqf estate, Lordship. So this is the Jamamandi. Subsequently, Lordship, page number 30 is a trace map.
Firstly, you refer to page
Page 28, Lordship.
28. Yes.
The patta is 585, Lordship, and the dag is down from below second 1654. The disputed dag where the direction was given by the GMC to allowing us to run a market, Lordship. So, Lordship, subsequently, in this, page number 30 is the trace map, Lordship. Lordship.
Yes.
The right hand side, if your Lordship will observe, this is the dag, Lordship, 1654. And across along with it, there is also a road. So, Lordship, thereafter the subsequent page number 31, this is the GMC order of the Lordship. Hereby, if I may read, Lordship, following receipt of the application from Muhammad Naif Ali, Mutwali trustee of Anwaruddin Waqf State, dated 9/9/25, and considering various aspects, the permission is granted in favor of Muhammad Naif Ali, located on the property of Anwaruddin Waqf State, situated in Bhangar, Gauhati, covered by dag number 1654, patta number 585 in the district of Kamrup Metro, for opening and running a private daily market for selling vegetables, fruits, fish, poultry, etc. at the market premises under the following terms and conditions. This permission is only valid for 1 year, that is from 1/1/2026 to 31/12/2026, Lordship. And in respect to, he also pay an amount, point number 4, that he has to pay an amount of rupees 15,000 per katha person. So with respect to this permission, we started running the market, Lordship. The claim of the petition respondent, Lordship, in the plaint is that in 1654, if your Lordship comes to a trace map, there is a road that passes through 1654, Lordship. And this Anwaruddin Waqf State, Lordship, we will know if your Lordship goes through GMC's road, right side there is a mosque named Anwarpur Mosque, Lordship. That mosque falls within Anwaruddin Waqf State. To go to the Anwarpur Mosque, a private road was facilitated, Lordship, so that the people from the locality can enter the mosque. That mosque, as per the plaintiff, passes through dag number 1654, Lordship. Now, that it is, since the road leads to that masjid, the road is named as Masjid Gali, Lordship. So now, your Lordship, that masjid 1654, and this is the 1654 is the Anwaruddin Waqf State, and the Anwarpur Mosque is also a part of the Anwaruddin Waqf State. That is within the Anwaruddin Waqf State, and the entire dag, your Lordship, this 1654, then 1653, 1659, all these are within Anwaruddin Waqf State, Lordship. Now, your Lordship, when this market was granted, allowed to us, we started asking the vendor that we have no objection there running a market, only that you have to enter into an agreement to run the market, Lordship. However, they had come up with the issue that saying that the Masjid Gali does not fall, there is a public road and it doesn't fall under Waqf State. So this honorable court on the first occasion asked them to produce document to show that this is a public road. Lordship. So from the first day, now they have come up with this document, Lordship. Lordship, first of all, Ulubari Circle said that the Masjid Gali they are referring to does not fall under Ulubari Circle, Lordship. Now, Lordship, the latest document that they have furnished today is the report from Dispute Revenue Circle, Lordship. That is in the additional affidavit they have filed in this page number 121, Lordship.
Yes.
Yeah. Lordship, in this affidavit, if I may read, that as per the land records available in the office and as per LRA staff report, it is seen that the land covered by DAG number 2675 under Beltola Mozai Sarkari Road, Sarkari government land, and in the remarks column, it is recorded as road. Now, we have no dispute with respect to this DAG, Your Lordship, 2675. Now, Your Lordship will come to the press map that has been furnished. Lordship, 2675. Adjacent to this is 2674. Then adjacent to this is the road. Now, my friend may clarify which road they are sitting and vending, Lordship. If they are sitting over 2675, I can give an undertaking that we have no objection to that, Lordship. 2675 is the GMCH road, Lordship. And I'm giving an I don't have any authority to run any market over GMCS road. 2675 is GMCS road, Lordship. Adjacent to this 2674, this is the PHC building.
The enjoined order is in respect of which road?
My is respect to 1654 over in within the DAG. We are saying that the road is there. We are not claiming any land over 2675 and 2674, Lordship. They are bringing down record 2675. 2675 is a GMCS road, Lordship. That road from Bhangor that goes to the overbridge that lands and that goes to the GMCH. That is a government road. I have no objection to that. And we have never sought any permission to run in the market over that road. If they are saying that their market is over 2675, 2675, we have no objection to that. Because the circle officer has specifically written in his report, the Lordship, that as per the land record available in this office and as per the LRA staff report, it is seen that the land covered by government DAG number 2675 under Beltola Mozai Sarkari government land and the remark column, it is recorded as road. I agree to that, Lord.
Yours is 1654.
2675, 2675, it is a GMCS road, Lordship.
In the suit before the work of board, this
Work of tribunal, Lordship.
work of tribunal. So what is the schedule there?
That is, Your Lordship. That is 1654. If Your Lordship will come to my plane, they have annexed it. We are saying that it is a plot of land measuring 4/10 lasa, as per the Zoromandi, Lordship, which encompasses a private pathway popularly called Masjid Gully. So I am saying I am respecting my claim only with respect to 1654. Anything beyond 1654, I have no authority. I am readily admitting to it, Lordship. Now, if they tomorrow, first of all, they are saying that 1654 it is under Ulubai Revenue Circle, Lordship. That can be only by spade verification that they lot model can come and say that see this is 1654, this road doesn't fall. Supposedly they say, and secondly, this is also a matter that can be decided only during trial, where if the concerned presiding officer allows us to conduct a spot verification whether this 2675 is the GMCH road or the road they are claiming. Because, Your Lordship, the diagram, if Lordship says, this is the road, this is the main GS road, Lordship. This is 2675 is the GMCH road. This side is the name care hospital, Lordship. No, I am saying, Lordship. Why I am saying, Lordship, 2674 the tag, that is a triangle plot of land. The Lordship, this is the land that PHC office is there.
The identity of the land itself is in dispute now.
Lordship, that has been determined by trial court.
So your document about dispute revenue circle, that's relates to a different DAG number than the one mentioned in the suit.
That is, without going to the dispute revenue circle report, we can decide on the basis of the report of the Gauhati revenue circle, because there is a Mondal report. You also will find at page 118 the Assamese person, and at page 117 is the translated person. It is stated that with regard to the subject and reference cited above, by conducting a field inquiry regarding the letter, it is seen that the land mentioned in the letter, Masjid Gully Road, Bhanagar, Gauhati, does not fall under the jurisdiction of the Office of Gauhati Revenue Circle. And the DAG number and Patta number and land they are mentioning, claiming about falls under the Gauhati Revenue Circle. That 1654 Patta DAG number is a land of Gauhati Revenue Circle, but that is the last boundary of the Gauhati Revenue Circle. Next to that, this Masjid Gully does not fall under Gauhati Revenue Circle. So if this road does not fall under Gauhati Revenue Circle, then how can they claim that since they are the owner of DAG number 1654, therefore they are also owner of the road in front of them, that Masjid Gully? Because the Mondal report is very clear that this Masjid Gully does not fall under the Gauhati Revenue Circle. This means their claim over this road is illegal.
If I may just.
And
Lordship,
it
may
is
just compare this
then
to
adjustment to various
test map,
part was
Lordship.
operating
Just-
under jurisdiction.
just a period, Lordship. The test map they have annexed their document, Lordship, in page number 30, that I have in the very first moment, that 1654, the disputed dark, Lordship. If you, Lordship, may just have a look on the said page number 30, Lordship. So these are both are their documents, Lordship.
This
Page number 30. No,
annexed by date.
I'm let me see, Lordship.
And
And
that's
the,
proper.
if a Lordship will now come to the affidavit, additional affidavit, this test map they have annexed in page number 123, Lordship. If Lordship may just keep this document together, Lordship, it will be very much apparent, Your Lordship, that this entirely the report they have brought is not with respect to this disputed land. Page number 123 of the additional affidavit, Lordship. The Lordship will say, now this additional affidavit test map 2675, adjacent on the left hand side of the 2675 is 2674, Lordship. There must be a plot of land with dark number so and so, and adjacent to this there is a road. Now they are saying that 2675 is the concern that they are concerned because they have been given a report by the circle officer that this is a government land. I am not disputing with this. If that being so, Lordship, then in this test map that they have annexed in page number 30, 2674 should have been there anywhere adjacent to this road because this is the GS road. So there, if that being so, these two plot of land, because the entire this road, Your Lordship, this adjacent plot, where can this 2674 land is gone, Your Lordship? So if 2675 is the road, they have brought the report with respect to 2675. I'm not disputing. This is a GMCS road. This is a government land, Lordship. And if these two trace maps are adjacent, Lordship, with respect to the same road, then they would have been, because then adjacent to this 2675, my land 1674, which should have been there because my council, learned friend, has very well submitted in the very first time, and for that his place of conducting business is adjacent to my land. So the road that he will be depicting will be directly adjacent to 1654. But in this test map he has brought, there is no 1654, Lordship. In fact, suppose this is a different avenue circle, this 2674 must have been here somewhere. It is not there, Lordship. So it is a completely different road. So it is they who are misleading it, Lordship. So definitely it is a matter that will be decided by trial court, Lordship, bringing on record all the relevant documents from both the circle. So at this time, I am saying, Lordship, this interim injunction was only till the next date. Rather than filing the written statement, bringing on record this document before the trial court, filing the written statement, they are proceeding before this court. And the trial court suit has not been Lordship, stayed by this honorable court, Lordship. So let the appeal before the trial court file the written statement, written objection, and Lordship may fix a time within a time limit of 15 days or 30 days. The suit injunction application should be disposed of, and I can give an undertaking that I will not take any adjournment in this period, Lordship. But the expeditious disposal, in fact, that will benefit them, Lordship. A finality will be received, Lordship.
See page 26.
Oh, see, so with so many disputes regarding the identity of the place, how do you expect
Very
us
clear,
to come to a
Gauhati
finding?
circle has stated that this road does not
Okay,
fall
you
under
may
Gauhati
keep
circle.
saying it's clear, but there appears to be a lot of confusion with regard to the place.
The Gauhati circle has stated that this road does not fall under Gauhati circle. Yeah, and Dispur circle stated that this road falls under Dispur circle. So he has property under Gauhati circle only, not in Dispur circle. So how can he claim that road? And this is a public road, Lordship. Masjid Goli, this is not his own property. It is a public property and he cannot claim any injunction over the public property, Lordship. It is not under his possession. Therefore, how can he claim it?
No, whatever.
And regarding
Whatever be the
map,
matter, this is to be examined by the trial court.
trace map, this trace map was filed by him in the Waqf tribunal. This is the list of annexers, list of documents, and I have annexed everything.
But he has relied upon,
From
Lordship. And this is certified copy trace paper, Lordship. The signature of the circle officer is there. But whereas the trace paper he has annexed, there is no seal and signature of the circle officer, Lordship.
It is report. I have no.
I have no challenge the veracity, Lordship, but
the only thing is that, Lordship, my simple prayer is there. Since the circle officer Gauhati has stated that this road does not fall under Gauhati circle, therefore he being the landowner of under Gauhati circle, how can he claim a land of Dispur circle to be his own land? That to a public road, Lordship. How can he claim his right over a public road?
Anwardin
And
Waqf
this-
State, Lordship, has land.
And this interim order,
Do you know Japariko also,
Lordship,
Lordship?
this interim order has the effect of a final order, Lordship. Therefore, that order also cannot be passed. And the circular officer is, dispute circular officer is given the photo of geotech lot. See, but it is at page 124. I think that this road belongs to the dispute circle. This is page 124.
Determined by the trial court.
This is the photo of the geotech lot. Photo given by the.
What is the position on the ground now? Are you running your business or not?
We are running lots.
They are running, lordship. We have taken no courtship step against them. As we have given the statement to the court that we will not take any courtship step against them, we have not taken any courtship step. Let them run the business, lordship, and accordingly let them file a written objection before the trial court. What is stopping them from filing a written objection?
Till disposal of the injunction petition, this interim order should not be given effect to. Because
It has not been given effect to, in fact.
It has not been given
they
effect.
went to the police without serving us any notice. They went to the police stating that we are violating the injunction order.
Lordship,
This is their conduct.
that is not
We
even
are
possible,
absolutely not
lordship. As per the civil procedure code, that is not even possible, lordship. An interim injunction step has been taken
Without-
within 24
when
hours, lordship.
We obtained certificate copy of the plane.
That is there.
They did not furnish us the copy. They did not furnish us the copy of the injunction petition also. But they went to
Lordship,
the court
steps
stating
were
that
taken
we
by
have
the
violated
process
the order.
server. Then
So this is the way they are running.
their revenge will
conducting.
be against the process server, not against the plaintiff, lordship. Plaintiff has taken steps within 24 hours and the affidavit of completion of service is within the record of the trial court, lordship.
It may be, but it was not served to the party then before it is.
That is their allegation. Allegation against the Waqf tribunal, not against us, lordship.
Now, your lordship will find this order 19.5. The earlier order was 12.5, and after 7 days they went to the court again, asking, claiming for violation of the order. This is the order, lordship.
Adhiana, affidavit on this one? This is additional affidavit. Second additional.
After 7 days, without serving the notice, they went to the court and court granted order to enforce the order by police.
That
This
is
is the
already
way,
put
without,
on record
without
to an additional
even serving a
affidavit.
notice.
The lordship, notice was
To the party.
submitted within 24 hours, lordship.
Unless your lordship pass any protective order, then they shall enforce this order again. Because these persons are running their business there for 40-50 years and this plaintiff does not have any right over that land. How can he claim an injunction order against these persons?
In fact, your lordship, as per latest development, some of the petitioners already entered into agreement with us during the pendency of this first appeal, lordship. No, that is.
My learned friends claim enforce them. Force them to do this.
So how can I enforce it when there is a appeal is being pending, lordship?
After 7 days, even these persons, nobody received a notice. They went to
No,
court again for violation.
Before the next date fixed.
Before the next date fixed.
The injunction violation.
The tribunal even did not even inquire whether the notice was served to the person, whether they have received the notice. No record was before this tribunal of serving of notice.
Specific signatures of the persons in the process server reporters there, lordship.
So may call for the record, may produce the record.
At this stage, lordship, trial court proceedings should not be stayed, lordship. This is my humble submission, lordship. This is just a delaying technique, lordship. They have all the documents.
If they're still conducting their business from that place, let the status quo be maintained.
That may be remained till disposal of the suit.
On the very first starting of
May remain.
submission,
We are
lordship.
safe, it may remain.
Lordship, my thing is that a time bound event should be there that they should be filing the attention or written objection within the next year, lordship. Because they are just waiting for the status quo order, thereafter they will not be proceeding before
No,
trial.
lordship. We are
No,
giving undertaking.
submission that
We
they will
shall
file
not
a
take a
objection
civil
next year.
judgment on
But
that matter.
till that they have not.
We
To
shall not
subsequent
take a
they have
civil
not, lordship, and they have not even taken given file adjournment petition, lordship. However, the trial court was lenient enough to say not to close the written statement, lordship, or proceed ex parte. Then they are giving allegation over the trial court, lordship.
IA 1817 of 2026. This IA has been preferred. Heard Mr. So-and-so learned counsel for the applicant and Mr. So-and-so learned. This IA has been preferred along with the connected first appeal seeking stay of the order dated 06/05/2026 passed by the learned presiding officer, Waqf Tribunal, Kamrup Metro, Gauhati, in Ms. J case number 08 of 2026, arising out of title suit number 25 of 2026 by an ad interim injunction, the applicants stroke appellants herein have been restrained from entering into the alleged scheduled land and carrying out business without entering into an agreement with the respondents. In the course of hearing of this application, learned counsel for both sides have referred to documents including reports of the Gauhati Municipal Corporation from a trace map, etc., pertaining to the scheduled land. There is a multiplicity of documents which require careful examination for the purpose of deciding the dispute in question, which also involves the identity of the actual suit land and in respect of which the ad interim injunction order has been passed. It transpires that after passing of the order of ad interim injunction, an application alleging violation of the said order was filed by the plaintiffs, pursuant to which an order was passed by the learned tribunal directing the police to execute the order of ad interim injunction, which is dated
19/5/20.
19/5/2026. Another order was passed on 29/5/2026. Issuing further direction to the OC Bhangagar PS to enforce the order and submit compliance report. Full stop. It is submitted that the appellants stroke applicants are still conducting their business as vendors on the said land, as they have been doing for the last several decades. Full stop. It is submitted by learned counsel for the respondent that the petitioner It is open for the petitioner to submit his, for the appellant stroke applicant to submit their objection before the learned tribunal, inasmuch as the present is only an order of ad interim injunction, and the disputed questions of fact can be decided only by the learned tribunal. Having regard to the fact that as of today, the appellant stroke applicants are still conducting business over the aforesaid land. This IA is disposed of with the direction that the petitioners, appellants may approach the learned tribunal by way of filing objection to the injunction petition, and upon such application being filed, the same shall be decided within a period of no later than 15 days from the date of 15. No, we'll fix a date for your filing the objection. Otherwise, I file an objection within a period of how many? 15 days? 15 days from today, whereafter the injunction petition shall be disposed of by the learned trial court within a period of another, let us say 30 days, another 30 days. Till then, the status quo as of today shall be maintained.
Reflected no coercive step may be taken against them because they are already.
Status quo will be good enough.
Same thing. All orders passed earlier by the learned tribunal shall be subject to the present instant order passed today. Instance disposed of accordingly. Now, what to do with the appeal?
We also dispose of orders.
The appeal you write in view of order passed in IA number 1817. The appeal stands disposed of accordingly.
Obliged.
Obliged.
Your Lordship. This is a MSc appeal, Lordship, statutory appeal. I mentioned it yesterday because Pakijai proceeding has been started, Lordship. It is on quantum, Lordship. We can deposit 50% of them. There is a IA also.
You have deposited the 25,000 and now you are ready to deposit what?
Yes, Lordship. 50% of the judgment amount. 25,000 is for filing the appeal.
Okay, hard to learn it counsel for the appellant. This appeal is preferred against the so and so. Appeal is admitted. Call for the TCR is to the respondents' steps by speed post AD within 3 days. List the matter again on IA. There is an IA.
Yes, Lord.
And this is condonation.
It was condoned, Lordship. IA has not come.
There is no IA.
File actually it was not numbered, so now today I think they have numbered this.
It is not on record here.
Actually, we need.
I think this is the condonation. Yes, this is condonation application. That is disposed of, I think.
We needed stay. Lordship, can Lordship pass the stay of the judgment in this appeal itself, Lordship?
There is no bar to that. The impugned, the execution of the impugned award is stayed until further orders subject to deposit of 50% of the award amount before the registry of this court. Who is the claimant? Respondent number?
1, Lordship.
Respondent number 1 may file application for withdrawal of the same. So advised.
Earlier, Lordship.
List again on.
Earlier, Lordship.
Hearing matters. Motion day. My lord. Got any urgency in this?
On the last occasion, the direction is given for taking instruction, Lordship.
Instruction regarding?
Regarding Lordship, whether the single judge can pass the order in the trial court, in the RCT, Lordship. Single member can pass the order.
This is regarding authorization. Was there any general authorization?
Yes.
For a single member to pass this order?
Lordship. No, actually, there is no such order is there. Specific, so far this judgment is concerned, Lordship. This case is concerned. This is a common, it's a common word. This is a common order. It is been given by the authority, Lordship. The instruction on the last occasion, this honorable court has given the instruction for taking the instruction, Lordship. But specifically, this court has inquired, Lordship, specifically any order passed regarding this particular case. Single judge can pass the order.
Is this a specific order specific to the case required under the law?
It is actually it is required, Lordship. If it is not, if it is no specific order, then single judge cannot pass the order. Single member cannot pass the order. The Supreme Court judgment is also with me, Lordship. On the last several judgment has passed, Lordship. This Honorable High Court also passed, Lordship. Lordship, may kindly peruse this judgment I passed, Lordship. The single member cannot pass the order. This Honorable High Court judgment, Lordship. Pursuant to the judgment passed by the Honorable Supreme Court, Lordship.
So that is why in this case, it was present case also, we were asked to get instruction whether there is any specific order.
Lordship, but there is no specific order. So it is remand the matter trial court again, Lordship. Because so far the single judge has passed the order in this case. Single judge cannot pass. Single member cannot pass, Lordship. Lordship, on the last occasion, this court's order dated 5/5/2026, para 3, Lordship. on this query was posed as to whether in the instant case, any general order has been passed by the chairman Railway Claims Tribunal under section 4 within bracket 4, empowering the member judicial to decide the claim sitting singly, particularly this case. Particularly this case, Lordship. And my humble submission was before this court that there was any order, Lordship.
So by this, what you have submitted today,
Lordship.
by these certain special circumstances have been mentioned.
Lordship.
So where DB is, quorum is complete, only DB will hear. Where it is a bench having only single member, then single member can. Is it not?
No, Lordship. Single member cannot pass any order. It is the Supreme Court judgment, Lordship, I have. Please.
No, this is your railway circular.
Yes, yes. No, that is railway
Office
circular.
order.
That is railway. But Lordship, they followed the High Court order, Lordship.
Yes.
One High Court order.
After that, there is Supreme Court order.
But Supreme Court judgment says no. Even that also, Lordship, this Honorable High Court query was that the particular this case, any specific order is there, the single member can pass the order. But I said no, Lordship. And that is the copy I have submitted before you, Lordship. This is the Supreme Court judgment, Lordship. In pursuant to this judgment, Lordship, that this Honorable High Court has passed the order. That copy I passed, Lordship, before you. Next page, Lordship. Kindly peruse the next page, para.
This relates to administrative tribunals.
Lordship, but it is covered by this tribunal also, Lordship.
How? Is it a tribunal created under the Administrative Tribunals Act 1985?
Yes, this is the yes.
Huh? This is a separate act.
That is true, Lordship, but it is also composition. The composition is same here also.
Position may be same, but
in pursuant to that, the Honorable High Court also passed the judgment, Lordship.
this is regarding this is Gauhati Tribunal. This order,
Lordship.
present order, passed by tribunal at Gauhati.
Yes.
So Gauhati Tribunal has how many members? 1 or 2?
There is a 2-member Lordship, but sometimes single member also pass the order. But that there must be a specifically order should be there if the single member pass the order. But particular this case, no special order was passed, Lordship. So it should have to be a double member, Lordship.
There is a Railway Tribunals Act. Pass on the copy of Railway Tribunals Act.
But even this, this case is squarely covered by the judgment lawsuit which I passed over. This Honorable High Court lawsuit. And more to judgment is with me, lordships. Page number 4, lordship. Number 4, para 4, composition of claims tribunal and bench thereof. Number 2, subject to the other provision of this act, bench shall consist of one judicial member and one technical member.
It says by general or special order. So by general order, it can also specify.
Lordship.
As per subsection 4 of section 4.
Lordship.
So what you have placed before us, what is that? Is that not a general order? Passed by whom? This what you have submitted today. There is never no reference to this in the judgment of the coordinate bench which we have referred to today.
That is referred by Lordship Amulya Chandra Kolita Supra. That is before you Lordship, which I passed Lordship, this then that order it is in the Relo case Lordship.
Confined to Admin Tribunals Act.
Lordship, this judgment is with me, Lordship. That is clear. That is in the clear Lordship. My lord, this order is this Honorable High Court. It is specifically.
That is the question I was putting.
Yes.
This judgment per se covers only administrative tribunal, but by this judgment, this principle was imported into railway tribunal also. This is Gujarat High Court.
This judgment, Gauhati High Court, this Honorable High Court, it is specifically mentioned everything, Lordship.
Which one?
Pathik Jyoti Shoikia Justice. Just I have given, Lordship.
This is by Justice Fukon.
Oh, Fukon, Lordship, sorry. Fukon.
Yes, you have anything to submit?
I have no any objection. Time limit may be granted for early disposal of all pending matter, my lord, in the year of 2000.
Right, we'll pass off the judgment in terms of the one passed by Justice Fukon. Not go into so many
Lordship,
issues of.
yes. That is
it is the agreed
yeah.
position.
Justice Fukon judgment is very clear, Lordship.
এখন judgment justice ফুকনের judgment মতে করে হেরিছে আসলে already
Obliged, Lordship.
May it please your lordship, my lord.
yes, what is this about?
This is also on the same line otherwise, my lord. However, on 2/4/2026, I was directed to obtain specific instruction, my lord. That, my lord, partial instruction I have received to complete the instruction, my lord may kindly fix the matter immediately after vacation, my lord. I will get that, my lord.
What instruction you have received?
The instruction is that, my lord, now it is completely against what was hearing, my lord, the last item. Whether now, complete different, my lord, whether I can submit that, I was thinking myself. Because section 4 says, my lord, of the Railway Claims Tribunal, my lord, general, some authorization by the chairman. Lord, in that view of the matter, whether, my lord, it's like 4 my lord, notwithstanding anything contained in the following provisions of section, it shall be competent for the chairman or any other member authorized by the chairman.
So the question is whether there is any such decision by the chairman or authorization.
My lord, yes, that authorization they have, my lord, forwarded me. It's of later dated, my lord, 23/3/2018. Something is there, my lord. Some
Not
authorization is there.
It may go against this. So ultimately,
My lord, so therefore, let me examine this, my lord.
yes,
after
exactly,
passing the
because
judgment, my lord.
after all,
Yes.
sometimes it may not be practical also, but there are so many vacancies.
Well, however,
Single member.
authorization is there, my lord. They have
That
said.
is what I'm saying, because there are so many
General
vacancies.
authorization, yes.
If there, even if there is no authorization,
Correct.
railway will be compelled to issue authorization, because
Right, my lord.
otherwise all cases will be pending as
Right.
long as the vacancy is
Yes.
not filled up.
That was, my lord, exactly taken into care of. And by the special general order, so for the claim of terminal charges are concerned, this was authorized to the single bench to take up in absence of the division bench. I will get the clarification from the department, because some judgment is also here against
And
side, my
if they
lord.
cannot take up, then that should be done at that stage itself, before the
Exactly.
tribunal, after going through an entire trial and then coming here and saying that this order is honest.
That is the.
Wastage of judicial time, public
Yes.
time.
Obliged, my lord.
Obliged, your lordship.